It has also been mentioned that the petitioner had also filed an application under Section 145 of the Code of Criminal Procedure 1973 in the Court of the Learned Principal Judge Family Court Kachar, praying for maintenance, which have been registered as FC Criminal Case Number 121 of the 2008. 8 or 18 or 8. The said case was proceeded ex parte against the respondent, and by an order dated 21/4/2009, maintenance was granted to the petitioner to the tune of rupees 2,000 per month for maintenance of the petitioner and 1,000 per month for maintenance of the child. Thereupon, the petitioner as well as the respondent have been living separately. The title suit number ESM case number 140/2022 was filed by the respondent seeking dissolution of marriage. It is the specific case of the petitioner that the petitioner that in turn fit to marry the Section 9 of the 13. It was the specific case of the petitioner that in turn fit Section 19 of the Hindu Marriage Act 1955. The jurisdiction lies in the court where the marriage under whose jurisdiction the marriage was solemnized, or the respondent at the time of presentation of the petitioner resides, or the parties to the marriage last resided together, it is only when the wife is the petitioner the presentation of the petition can be made The exception to the above is in the case of a wife residing at a place on the date of presentation of the petition. The learned counsel appearing on behalf of the petitioner therefore submits that as the marriage was solemnized within the in the district of Pachar, the respondent, the petitioner who is the respondent in the said suit was a resident in the district of Kachar, and both the parties resided together at Kachar. The jurisdiction, the court, the district court, the district judge, the learned district judge, Chipsagar, did not have the jurisdiction to entertain the instant application in view of Section 19 of the said Act of 1955. This court have duly taken note of the pleadings in the instant petition, and from the materials on record, it is clear that the petitioner herein, that the marriage between the petitioner and the respondent took place within the district of Kachar. Both the petitioner and the respondent last resided within the district of Kachar, and at the time of filing of the petition, the petitioner, who is the wife, resided, who is the respondent in the said proceeding, resided within the district of Kachar. So accordingly, this court finds this to be a fit case for transfer, exercising the powers under Section 24 of the Code of Civil Procedure 1908 for transfer of the proceedings. Being title suit M, case number 140/2022, from the Court of the Learned District Judge Shivsagar to the Court of the Principal Family Court, Family Judge, Family Court, huh? What is that? Principal Judge Family Court, Kachar. You have filed your written statement? No. Taking into account that both the parties are represented in the instant proceeding, the parties are directed to appear before the Learned Principal Judge Family Court on 1st of July 2024. On that date, the petitioner herein is directed to file her written statement in the said proceeding, in the said divorce proceeding. He is given the liberty to file her written statement on or before the next date so fixed by this court. The court of the Kachar, the principal judge Kachar felt thereupon taking by any solo opinion. First, 1-7 appear and then file your written statement. Yes, what is it?
Sir, on 29 this honorable court directed file the counterclaim along with the written statement against the counterclaim. I obtained the certified copy, my lord, but one document I could not able to translate it because day before yesterday I got from certified. May I say that since for 3 days I translated, and one affidavit I have filed, additional affidavit, but except that document. Except the counterclaim. But in fact, the case counterclaim is, I have not challenged the order of the counterclaim. I have challenged only the decree passed by the court below in favor of the plaintiff.
What are your substantial questions of law?
Substantial question of law, my lord, the page 9, my lord, whether appellate court art in law in declaring right title interest of the plaintiff over schedule and within schedule 1 land, also when the entire plaintiff share acquired by way of inheritance has already been sold by sale deed number so and so exhibit 7 in favor of the.
It's a question of fact. It's a question of fact. He has already sold it. Then if it is sold, whether he is out, whatever may be,
Sold to us.
whatever may be, but sold to you, it's a question of fact. Isn't that a question of fact?
My lord,
If he has sold it, it is whether he has erred in law. Erring in law is not a question of law.
my lord, kindly see page 82, my lord. Page
No, it has to be a question of perversity. You
But-
have to bring a question of perversity.
that perversity
Whether
is in-
non-consideration of this document in the proper perspective would have been would have changed the position.
page, substantial question of number
3. So how is this a substantial question of whether the learned courts below erred in law? Erring in law is not a substantial question of law. You need to understand, Mr. Ghosh, you are an expert in civil law.
my lord, kindly
Can these be the substantial questions
That-
of law?
that can
People
be-
will laugh.
my lord,
The High Court has gone. Questions of law, these are questions of pure questions of
my
facts.
lord,
And erring in law is not a substantial question of law.
your
The
lordship,
substantial question of law has to be such that if that consideration of that document would have been taken in that, then in that case, it would have changed the entire course of events.
actually, I want to reformulate it.
Fantastic. Take that. But not all these things about these questions of law are not.
Page 82, kindly see, my lord.
What?
Page 82 of
What is your case?
my
That-
case is that when the court, lower appellate court,
No. What is your case? You were the defendant.
I am the defendant. Lower appellate court,
A
I-
suit was
I-
filed for right, title, and interest.
I am not plaintiff.
Understood? So you
Recovery
say
for-
you must have said out there, look here, he has already sold this property to me. Where is the question of right, title, and interest? Is that
And
the
that finding is in my favor by the learned lower appellate.
show me?
Page 82.
Yes.
As per the original pleading, admittedly the Schedule 1 land has been purchased by the defendant number 1, predecessor of the appellant from the predecessor of the respondent. That is the original plaintiff. Other three co-owners, sharer and owner, and thereby admittedly same is not an inheritance claim. Over this land, they want recovery of possession.
Then further, there must be
Further,
good
The
reasons
fact
given.
of the aforesaid land being owned by the plaintiff aforesaid co-sharer as per amicable partition is also not disputed. This, my lord, this regard to the partition with not with respect to the suit land, with respect to other land of the
Let us read
register.
paragraph 18.
18.
Yes. 18, page 82.
18 I am
82.
page 82. Yes.
The fact of the aforesaid land being owned by the plaintiff so and so as per amicable is not disputed, rather admitted.
It is also an admitted fact that defendant number 1 came into possession of the aforesaid land after its purchase in the year 1964. There is nothing in the pleading or evidence being adduced by the defendant number 1 that he is in possession of the suit land since earlier to the aforesaid purchase. Rather, his evidence shows that admittedly he came into possession of the suit land after the purchase of Schedule 1 land by him. The fact of amicable partition between the original plaintiff being the son of Tayab Ali and other co-sharers, that is, other sister of Tayab Ali, namely so-and-so has in the plain. And as per the said amicable partition, Schedule 1 land being owned by the aforesaid heir of Abdul Mia, which is subsequently being purchased by Abdul Noor, defendant number 1, is an admitted fact. Hence, the aforesaid fact shows that the amicable settlement among the original plaintiff and the aforesaid other co-sharer, as stated above, is an admitted fact. The only fact denied is that, as per the said amicable settlement, the Schedule 2 land fell in the share of the original plaintiff. However, it is an admitted fact that in the sale deed, Exhibit 7C, by which the aforesaid land, Schedule 1 land, is purchased by defendant number 1. The Schedule 2 suit land, being the eastern side of the said Schedule 1 land, is mentioned to be the land of the original plaintiff, predecessor of the respondent. As such, prima facie admittedly, as per aforesaid sale deed on the eastern side of said purchased land, Schedule 1 land, and the land of the register of the respondent, the original plaintiff is situated at Schedule 2 land. Particularly, the aforesaid sale deed is not executed solely by the original plaintiff predecessor of the respondent, but also the other aforesaid co-sharer heirs of Abdul Mia. Hence, admittedly, as per all aforesaid co-sharer being the seller along with the original plaintiff predecessor of the respondent, the Schedule 2 land being the eastern side of the Schedule 1 land is of the original plaintiff predecessor of the respondent. It appears that though the counterclaim for rectification of the concerned deed is made, however, there is nothing on record showing any such claim for rectification of concerned deed being made against any other seller except original plaintiff of the respondent, which has as such on the face of it not substantial, rather not maintainable. Admittedly, the defendant number 1 came into possession of Schedule 2 land as per amicable partition. However, there is nothing specific in this pleading that as per which amicable partition of the amicable partition among whom the defendant number 1 came into possession of said land. As per the aforesaid pleading of the defendant in view of the amicable partition, the second scheduled land fell in the share of Asira Bibi, the mother of the original defendant number 1, and the defendant number 1 subsequently came into possession of the same as per amicable partition. Pleading the defendant suggests that the amicable partition as alleged by them took place during lifetime of Asira Bibi. But there is nothing on record showing Asira Bibi was ever in possession of the suit land. Rather, the evidence on record, P2, Johed Ali being son of Asira Bibi, suggested that Asira Bibi during her lifetime stayed her matrimonial home and fled to
Where is page 4 of the plain? Page 4 of the internal page 4 of the plain. Annexure 1, page 10 is the plain.
13.
Yes.
Page 13.
Huh?
Page 13.
Where is page 13? Page 13 is page 3. Read it on top. So we dismiss it on that ground. We have been given enough time. Without having page 4, where is the page 4? Mr. Sharma, you have page 4
Yes,
of the plain?
page 13 is page.
No, page 13 is page 3.
There may be some mistake in that case. Page 11.
Annexure 1, page 10. This is the
Page 10 is
copy of plain.
the first page.
First.
Oh, page 11. Page 11 is the fourth page.
Page 11 is second page.
For declaration, the plaintiff has got landholder right and in respect of the landed property that is described in Schedule 2 below and confirm plaintiff. So plaintiff only asks for Schedule 2. That is why I want.
Schedule 2.
Now, where is the court's finding that Schedule 1, the Schedule 2 is your land?
That my lord kindly see.
There's nothing out there. What you were referring to is of Schedule 1. Schedule 1, the court admits. The court categorically holds that, look here, in the sale deed which on the basis of which you are claiming Schedule 1, on the eastern side there is Schedule 2. And as such, that land is completely outside Schedule 1. That's the case.
That's the case.
What is wrong?
Now finally Schedule 2 of the plain. And I will show the sale deed as well as evidence of PW2. Schedule 2 land. Boundary in west, my lord. purchased land of the defendant number 1. This
Hmm.
much is correct.
Hmm.
But they have added as well as the path of existing towards west in the northern side of the landed property described in Schedule 1 above. That
Now let
means
us see.
this-
No,
this-
let us see what have you stated in your written statement. That schedule 2, that aspect is wrong. Where is it? The written statement starts and finishes. Nothing mentioned.
my lord, page 23. Plaintiff of their register Ismail Ali was not the owner of second schedule land. As such, defendant number 1 had no reason to approach the plaintiff for construction of the house. It is to be mentioned that Abdul Mia died leaving behind his son so and so, Asira Bibi, and second schedule land fell in the share of state Asira Bibi as per amicable partition and took place long ago before 1964 and heard and stated above. And after death of Asira Bibi, an amicable partition.
No, that is nothing to do. Where have you stated anything about Schedule 2? Schedule 2, there is a finding of fact of both the courts below that land falls in on the basis of whatever the it has been stated. Where have you said that sale deed, the boundary mentioned out there in Schedule 2 is wrong?
My lord, may I show the evidence of PW2?
No, absolutely no.
Because
Where is that? There's nothing out there.
PW2's evidence.
PW2 is not there, but first of all, the court categorically holds whatever may be.
And
There.
kindly see the sale deed, my lord. Exhibit 7, kindly. Exhibit 7. From the Exhibit 7, it is clear if there is a road. I do not have any objection, my lord. In the Exhibit 7, there is nothing. Except Exhibit 7, they are entitled for Schedule 2. But when the Schedule 2 has been mentioned, by incorporating the land from Schedule 1, from my sale deed.
Land of Muhammad Ismail.
Yes.
Who is Ismail? The owner. Land of Muhammad Ismail, seller.
Yes.
And the plaintiffs are successor in interest of Muhammad Ismail. Do you have any other document to show the defendant that you have any right over the Schedule 2?
Our right.
Yes.
We actually, in the counterclaim, we have claimed that we being the one of the legal year, I am also.
Your counterclaim is dismissed.
Dismissed.
You have not filed an appeal. But it does not say anything.
Counterclaim because
Whatever may be, but the fact remains that you have, when it is been dismissed, it is already ended. Now, is there any document to show, or did you produce any document to that effect as regards Schedule 2 land? No.
my lord, regarding counterclaim, earlier.
Again, you are coming to counterclaim has no business.
Earlier, this court demanded the matter on that ground, and thereafter decided in a single order, by passing a single judgment. That judgment is undertaken.
There can be 3 suits, 4 suits together decided by one single judgment. That is the mandate of Order 41, Rule 1.
But only question is, my lord, whether they are entitled for my land or not.
No, it is very clear that you have a right over Schedule 1 land.
No. Schedule 1 land is entire. In plain, kindly see what is.
Now, are you saying in anywhere in your written statement that Schedule 2 land which have been described in the plain is a part of Schedule 1?
My lord, in the plain.
It is your stand in your written statement that Schedule 2 land is a part of Schedule 1.
That landed property described in Schedule 1 land below originally in the
Again,
plain.
you are coming to
In
all
the
this.
plain itself, they are said
We
that.
are not concerned with that.
Schedule
My
2 land.
specific question, Mr. Ghosh, is very simple. Have you stated anywhere in your written statement that the Schedule 2 land is a part of Schedule 1? Otherwise, all other land except what has been mentioned in the deed of sale belongs to the plaintiff, whoever it is. So they rightly decide.
But that part also not, they have been not able to prove that.
Yes, Mr.
Schedule 2 land
Mr.
is their
Sharma,
land.
you want to add something before putting the death nail on Mr. Ghosh's appeal?
So there is actually nothing to interfere with the judgment of the court below.
Yeah.
And even though the landed, the plaintiff is able to prove that the Schedule 2 land is theirs and Schedule 1 land is sold. And they claim the boundary is wrongly put.
Hmm?
Boundary is wrongly mentioned in the sale deed
Where they came in their written statement.
in their counter.
But the counterclaim is dismissed
Therefore,
and
there-
they have not filed an appeal against it. Matter ends there. Anyway, you can very well take up this issue in your execution, can't you there?
But so far with my lord,
But your counterclaim is dismissed. You
no,
can't help it. Counterclaim dismissed, then you didn't file a first appeal. Did you raise the points in your appeal as regards the counterclaim? In your memo of appeal? The suit is for 4 pages, plain. Written statement is of 4 pages. Judgments are written long. And the matter has become so. The issue is very thought as to whether the schedule 2 land. That is why that page number 4 is very relevant of the plain. There only you see the relief which has been sought for is only as regards declaration and confirmation of declaration as regards schedule 2 land, not for the entire.
but it's a
Let's see how what did the trial court give. The plaintiff has right title and use right have the right to use the path existing towards the west on the northern side of the land described in Schedule 1.
my lord, in the issue number
Plaintiff
4,
has right title and interest over Schedule 2 land and the original defendant is a licensee. The plaintiffs are entitled to get recovery of past possession of Schedule 2 land described in the plain by evicting the defendant or their family dismantling of Schedule 2 land.
is 45 of the trial court issue whether defendant is entitled to get the document executed by the plaintiff as claimed in the contract.
Schedule 1, which have been mentioned in the plain, is this land. Is homestead of Abdul Rahman. Who is Abdul Rahman?
Abdul Rahman is third part.
No. Schedule 1 land
Yes.
belongs to you. Does it belong to you?
Schedule 1 land, court below held that Schedule 1 land is belongs to me. But
N-
when they have
But Schedule 1 land on the east has been shown as the land of the plaintiff.
Is not Abdul Rahman.
That is why I am saying east is land of Muhammad Ismail Ali number 1 seller
In
and
schedule
sell.
two, in schedule
Seller self.
in schedule
This sale deed is made of what? Annexure 8, page 103.
sell it is in my paper.
It is what? What is the east?
East, yes.
East is what?
East is the land of Muhammad Ismail Ali, number 1, seller number 1. That is who is the plaintiff in this case. And west is Boro Gopat, north is land of Nimar Ali, south is land of Kalamia.
Let us see again the finding at paragraph 18. Mr. Sharma, don't you think that there is a mistake committed by the first appellate court? You see, your claim in your plaint, see paragraph 1 of the plaint. What you stated in your plaint is Schedule 1, 2 land is within Schedule 1. Isn't it mentioned? Now you say that on the western side of the Schedule 1 land, they purchased 8 dusty and whatever land. Okay. Now, why does the first appellate court hold, as per the original, admittedly, Schedule 1 land has been purchased by the defendant number 1 predecessor of the appellant from the predecessor of the respondents? The entire thing, isn't it wrong?
Well, the landed property described in Schedule
That
2.
is why there is no mismatch. There is a mismatch with the boundaries of your schedule of Schedule 1 with the boundary with the sale deed. Because the sale deed, not with this boundary, there is no problem with this. Therefore, it doesn't tally. Because the Schedule 1 land is a much bigger portion of land. The area is how much?
19.5.
Where is it?
That is also not mentioned in the sale deed, my lord. In the sale
No, it is given. It is given. No, in the sale deed,
In
it
the
is
sale
given
deed.
8 justice, 9 poor.
in the schedule HFT 9 point. But
Kindly see page 103.
yes, I am.
It is given
given.
HFT 9 pounds was sold to you.
Sold to me.
And here it is given 0.196 acre.
Acre.
So 0.196 acre was the total land. How much was that? How much was that? Because here, if this finding is removed, don't you think that the court, you need to file an appeal? Let's see how the trial court decided. Because tomorrow, it was admitted. The perusal of the evidence below shows that the parties are remand PW1, he said all these things. It's so long. And the learned first appellate court has used the word admittedly countless. The fact remains that the Schedule 2 land, he has not been able to prove. That is why the difference of let's see the trial court judgment. Trial court judgment is better. How does it take? Whether the plaintiff has right title interest over the suit, is entitled to get the document executed by the plaintiff as claimed in the counter. What was the counterclaim?
Counterclaim that in the sale deed, there was a, in the eastern part, it wrongly mentioned the name of the plaintiff for correction of that deed.
So you filed a 23 or 26 of the specific review. That was dismissed,
That was
not point. So how much would be the area? 0.196 acre?
196.
Now the plaintiff's title has been declared on what basis?
It is the inherited property.
Huh?
Inherited property of the liable.
And the defendants duly admit
Yes.
that Ismail Ali was the owner. You
Ismail Ali-
admit.
We admit that Ismail Ali was the owner. After his death, all the legal heirs, including the plaintiff, executed the sale deed in favor of that.
Understood, but only for Schedule 2. 1. Not Schedule 1 also. You
Wait,
have only got for
Eight,
the
eight,
Schedule 8,
nine.
8 just in 9 points.
Yes.
Nothing more than.
Nothing more than
But you admit that Ismail Ali was the owner.
Ismail Ali was the.
So that you admit.
Yes, but now whether apart from that there are other land or not, that they have not been able to prove, except the sale deed in the mention that in the eastern side, Ismail Ali. There is no other document they have proved.
Others they have proved is the revenue record.
Revenue record,
Khatian.
revenue rep.
Khatian in the name of
Khatian.
Ismail Ali.
Only Ismail Ali.
Understood.
Only Ismail.
Now the question is, you are not a co-heir. Are you a co-heir?
Oh yeah,
How do you say so?
my mother. The mother of the
Have you asked for partition?
that
That is not your case.
not my.
So don't come up with that.
But we are claimed that we are the daughter of my that Ismail Ali. Oh, not Ismail Ali. Sorry,
Right.
daughter of Sayyab Ali. That is an admitted fact.
The mother of defendant number 1 pre-registered.
Who is Joad Ali? Your cousin.
Yes.
You are the son of Asira Bibi.
Asira. And Asira is the daughter of
Asira Bibi died in the year 1930.
there. That that was the dispute.
But the
Dispute is that we are claiming that we are not predeceased with father Asira Bibi.
when did Asira Bibi die?
We are claiming that Asira Bibi died in the year 1951. 1951. Asira Bibi died in the year 1948. And Ismail Ali died in the year 19. That is we have claimed that Asira Bibi died 1950.
So how much was the land left behind? Because you are the daughter of, your grandmother was the daughter of Abdul Mia.
The
Abdul
original
Mia died in the year 1946. And how much was the land? How many sons and daughters he had? Abdul Mia?
Abdul Mia.
And how much land he had?
There are other land also.
You mentioned it.
No, it was not
Commit within your share.
because with our claim is that with respect to this property, only with respect to this property, after amicable settlement, this property has been given to
Amicable settlement with whom?
with all the sharers.
When? At the time when Abdul Mia was alive.
After
So the amicable settlement happened with your mother, or did it happen with anybody else?
other legal head. Mother, that Asira Bibi died when the main fact. We are claiming that Asira Bibi died in 1950.
Asira Bibi died in 1950. And these amicable settlement happened when?
They said that after death of that is in 1956.
46.
Not 40.
46, Abdul Mia died.
Abdul Mia died. Thereafter, no amicable settlement.
It happened before.
After
After
death
or
of,
before?
after death of Asira Bibi.
Asira Bibi happened. That means after Abdul Mia died, the amicable settlement happened.
Yes.
And who are your evidence?
Amicable settlement mentioned 1964.
And when did this deed happen?
Sale deed, 1964.
So at the time when this sale deed happened, it was in the name of the defendant number one.
Sale deed. Not only defendant number one, other there.
Wait. The defendant number one was a party who got the benefit out of this sale deed.
In the sale deed, it mentioned that they acquired the title by way of inheritance. That is mentioned in the sale.
Whether there was a sale deed made or not.
Yes.
In the favor of the defendant number one or not.
Yes.
This happened in 1967.
60,
Only don't confuse this.
64. 60.
After the death of Asira Bibi.
Yes, after that.
And also after the amicable partition.
Yes.
Then also you have shown on the southeastern boundary, Ismail Hussain is there.
Ismail Ali.
Why? Why that eastern boundary was not shown? Because the amicable settlement happened in 1950. Why? What is your answer?
My lord, answer to this that when the sale deed was executed,
and why after 30 years you woke up? This is how the link is. If let us assume everything to be correct, why did you mention Ismail Ali not yours on the eastern boundary? If that was the work you got in the as per the amicable settlement?
my lord, so far with respect to amicable settlement is concerned, the amicable settlement not with respect to this land, it's with respect to other land. And this land,
Mr. Ghosh, kindly don't try to confuse.
no, not confusing. I want
Let
to
us
say
make it very clear.
this
Your
land,
your specific case is, you see, this schedule 1 land, the schedule 2 land, was the land which was inherited by your mother, Asira Bibi. Your mother died in the year 1950. Your mother's father, the grandfather, died in the year 1960. That's your case. In the year 1950, there was an amicable settlement wherein you claim that this land fell into your share. And this is very clear from there. Then in 1964, why a sale deed was made showing that this very land, Schedule 2 land, which is on the eastern side of that, your land which was sold, belonged to Ismail Ali and not to you.
my lord, so far,
And then after 30 years, you wake up and file a counterclaim.
my lord, so far with respect to my lord, amicable partition, that was not accepted by both the court below. Both the court below did not accept.
I'm not on that. Your case is about amicable partition.
But,
No, I
that
am
was not
saying
accepted.
I am saying on the logical explanation to what you are saying.
My lord,
It
my
is not probable. You see, the learned first appellate court said, why it took 30 years? The learned first appellate court came to a finding that Asira Bibi predeceased the father, as you have also not laid down any evidence to the effect, because your father, Rashid Ali, whoever, after the death of your mother, again remarried in the year 1930. And this is being proved on the basis of Exhibit 9. And Rakib Ali happens to be the son on the basis thereof. And Rakib Ali's age has been shown as 35 years on the basis of the voters list of 1965. This is the proof they have. What proof you gave? Nothing. To the effect that my father could have married twice. There's no problem with that. During the lifetime of my mother married, could have been said. Did you give that?
My lord, so far with respect to cell deed is concerned, I am again submitting that so far cell deed is concerned, my lord. In the cell deed mentioned that we have the defendant have right over it with respect to cell deed exhibit 7. They cannot claim any right over exhibit 7 land.
No, they are not. They are not claiming that.
That is why I am saying that exhibit 7 PW2 as well as in the plain. From three evidence, it is clear that portion of schedule my schedule cell land has been incorporated in schedule 2 land. Portion of this land has been incorporated.
Where is your statement to that effect in your written statement to make it up, to have it as a foundation for framing a question of law? That is not.
My lord, that is why I'm
You want
perversity
now
with
to
respect
the
the-
matter to be remanded back to you file a fresh written statement.
No. For with respect to perversity. that
What is the perversity? There is no perversity.
My lord, the learned court below, the lower appellate court had declared that it admittedly schedule 1 land is belong to the plaintiff, defendant.
You see, that was a wrong thing done by them.
But they have not filed any appeal.
Maybe. If it is a wrong, it is not the fight. But see the ending.
Ending is against me.
Ending is against you.
Ending against.
But if it is a wrong thing, which is never the case of the plaintiff, plaintiff's case was specific. On the western side of that land of Schedule 1, that land was only sold to you.
That land has been sold to me. But when this Schedule 2 has been mentioned, my whole land has been incorporated.
Where is your statement?
In the schedule,
Okay, 11:30, 11:45, I'm coming and dictating it. Enough. Too much time.
my lord, with respect to that, my exhibit 7 may be protected, my lord. Exhibit 7.
Exhibit 7, I'll protect it.
That
Exhibit 7 is protected for that purpose that the court has also. There is the Schedule 2 land. It is that I'll mention in the order that the plaintiff duly accepts the selling of the land which has been mentioned by the deed of sale dated so and so.
Fine.
Okay.
that protection, because otherwise, what will happen? They will execute from my land.
Whether they execute from your land or not, that is for the executing. Not.
So
Still, I'm
if,
coming back.
if it is clarified, then it will be.
Not the clarification there. In fact, they didn't get the good advice from Mr. SK.
There.
But in the definition that was mentioned that there is no road in a was
There is no
Yes.
road.
the plaintiff has no right over the road mentioned in the plain. It is totally false that after taking permission from the plaintiff, defendant were doing the right over the road. So road with respect to that road, there's no road.
We are not concerned with any other road. We are only concerned to the fact that whether it affects your right. Your right is limited to the sale. So if the road falls in the sale your sale land, then the road is not there.
But in prayer, prayer B, we have prayed for the for a declaration that the plaintiff has got right to use the land existing on the northern side with landed property as described in Schedule 1. Page 14.
What is that? For
Eh.
planting permanent income.
Internal page 5.
Yeah, what is it?
Top of the for declaration that the plaintiff has right of user of the land existing northern side of the landed property as described in Schedule 1. There was a 4-feet path from Schedule 2 to the main road.
But does it fall within Schedule 2, Schedule 1 land? Heathland. It falls in heathland, the question does not stand.
Because that was the road used for aggregation interest from the main road to Schedule 2.
But where is the finding to the by any of the did the court run that?
There was no fine.
Please, page 49.
Yes.
So this court finds no hesitation to declare that the plaintiffs have right to use the part existing on the northern side of the Schedule 1.
Where?
Page 49.
Page 49, which portion?
Last part of the paragraph 1. Top.
Last part of which one?
On the paragraph prior to the issue number 5, that is the
No, as regards right title over the Schedule 2 land, there is no quarrel with that. But what about the road? Unless the court finds that that portion is also the road is there, because Schedule 2 road is not there.
road is there. We have
Kindly see Schedule 2. On the west there is a road. See the You see, so this court finds no hesitation to declare that the plaintiffs have a right over use of the path existing in the northern side of the Schedule 1 land, and the plaintiff has right, title, and heir over Schedule 2 land. There's no quarrel with the Schedule 2 land. But if you see Schedule 2 land, the land is outside, you are asking for a declaration of your right title only in respect of Schedule 1, Schedule 2. But you are asking for a declaration that you have easementary right over a portion of the Schedule 1 land. Now, is it your case that the defendants are in possession of the Schedule 1 land? You are saying about the northern side. You see, existing in the northern side of the landed property of Schedule 1. If it is the northern side of the scheduled property of Schedule 1, that is a road which may be outside or maybe within it, but it cannot touch the Schedule 1, the property which has been sold to them. Is it mentioned that that road falls in that his land? There's no mention anything about the road.
Paragraph 5 of the plaintiff document, page 12.
So where is the finding to that effect? Here in the trial court judgment, there is a finding to that effect.
Yes.
Finally come to page 47. The record speaks that after the institution of the suit, that is by so and so, my predecessor in the office inspected the suit land and also prepared a sketch map of the sketch map clearly discloses the existence of the said path in the northern side of the Schedule 1 land, which is connected to the so and so, and deposed that the land described in Schedule 2 has been inherited by the original plaintiff from the father and the so and so. But there is nothing to say that that land falls in Schedule 2, falls within his share. How can the court give a declaration to that effect if that is so? Therefore, we admit that on this part, the escape court, the appearing A. Sharma, the learned senior counsel, representing the respondent numbers, all the respondents, responding the learned senior counsel is set by all the principal respondents.
Yes.
All performer.
All 1 to 21.
And what about the performer?
Oh, we have not-
Appear Mr. Half of the respondent numbers 1 to 21. The instant appeal is admitted. And this is an appeal directed against the judgment and decree dated 10/6/2022 passed by the learned District Judge Karimganj in title appeal number 02/2018. The appeal is admitted on the following substantial question of law: whether the learned courts below were justified in decreeing the suit holding that the plaintiff have right to use the path existing towards the west in the northern side of the land described in Schedule 1, though admittedly from a perusal of the plain the declaration sought for by the plaintiff is only in respect to Schedule 2, and the western boundary of Schedule 2 mentions about the existing path. Call for the LCR.
Yes.
Taking into account that the respondent numbers 1 to 12, 1 to 21 are duly represented, the no notice is required to be issued. However, extra copy of the memo of appeal is served upon Mr. G. Bharadwaj, the learned counsel, appearing on behalf of the respondent numbers 1 to 21. What about the performer? Mr. S.K. Ghosh, the learned counsel, appearing on behalf of the petitioner, appellant, submit that the performer, the respondents herein, did not participate in the trial, as well as also in the appeal proceedings. He therefore submits that the names of the said performer, the respondents, number 21 to 22 to
40.
40 is struck off. Taking into account the above, the names of the performer respondent number 22 to 40 is struck off. The counsel for the appellant is directed to file a fresh memo of parties by 16/5/2024 before the registry of this court, and the registry of this court, on filing such memo of parties, along with taking into account the order passed herein, make necessary changes in the post title of the appeal memo, as well as also update the same in the CIS. This court further finds it very relevant that the issue involved, the substantial question of law so framed, may not require much more deliberation, taking into account that the matter has been substantially heard. Accordingly, fixes the instant appeal on 26/2024. for hearing. The registry shall take effective steps for getting the LCR.
LCR receipt.
Oh, it's there. On 26, 2010. On which date an attempt shall be made to dispose of the appeal. I think only we put that on others, but we can't say the trial court was wrong or the first appellate court was wrong. That only that. How could that road be given? You have asked for right title interest in because that so you have got. But somebody else wrote because you see the Western County. The Western County categorically say the road which is there. Now the west of that schedule 2, and as per his tailgate, the east is his. That means his land. They could not have given unless there is a declaration to the effect that this land can be allowed. That's why his right of over his rights over his land taken. When you have to be admitted without claiming that substances could not go, I could not. Then if the records are there, we can dispose it early.
Yes, because it is suit of 1998.
So we do it one thing. We have already heard that matter. So on the day it may not be proper. So we'll have it on 28. 28. You make that correct. If the
By Monday,
so we interfere with that effect.
Yeah.
That should not have given. It has been substantially heard.
M1.
Yes, Mr. Khatter. You won't sell. Let the injunction.
not only in respect of Schedule B.
It will be. This is an appeal under section 104 read with order 43 rule 1R challenging the order dated 22/11/2022 passed in Ms. case number 87/2019 arising out of title suit number 68/2019 whereby the learned trial court had directed the parties to maintain status quo regarding alienation of the transfer of the suit land mentioned in the schedule of the plain till the disposal of the main suit. The learned counsel appearing on behalf of the appellant submitted that the said order on the face of it suffers from total non-application of mind, taking into account that it was never the case of the plaintiff that the plaintiff had any right over the Schedule A land.
B is part of it.
Naming that it was never the case of the plaintiff that the plaintiff was entitled to the entire Schedule A land. The entire claim of the plaintiff was on the basis of Schedule B. And as such, the injunction order could have only been passed, if at all, in respect to the Schedule B land. In addition to that, the learned counsel submitted that the Schedule B land is not properly described. And as such, the said Schedule B land could not, and no injunction ought to have been granted. In that regard, the learned counsel has drawn the attention to Schedule B to the plain, wherein it is seen that there is a mention of land measuring 2 bighas, 2 kathas, 10 letters covered by dark blank. Yes. And there is no mention. Under such circumstances, the learned counsel submitted that when the Schedule B is vague, the learned trial court ought not to have granted the injunction. On the other hand, Mr. L. K. Bora, the learned counsel appearing on behalf of the appellant, respondent, submitted that the perusal of paragraph number 7 of the plaint submitted that no doubt there has been an inadvertent error in mentioning the Schedule B by which was a typographical error in not inserting the dark number. However, the same can be very well discerned from a perusal of paragraph number 7, wherein the land measuring 2 bighas 2 katha 10 lecha was in respect to dark number 121 as stated in paragraph number 8. Upon hearing the learned counsels, this court has put a specific query upon the learned counsel appearing on behalf of the appellant as to whether the appellant would like to transfer or alienate the suit land pending disposal of the suit. The learned counsel submitted that there is no inclination on the part of the appellant to transfer or alienate the Schedule B land. However, he submits that the right over the Schedule B land rests upon the appellant, and an injunction to prohibit an injunction restraining the appellant to exercise its rights, including the right to alienate, if continued for a long period, would be prejudicial to the interest of the appellant, taking into account the business of the appellant being in real estate. The real estate. Taking into account the above, this court, upon perusal of the impugned order, do not find that the learned trial court had committed any illegality or the order suffers from non-application of might or has been passed in violation to the provision, principles of grant of an injunction. Be that as it may, the learned trial court ought not to have directed, restrained, ought not to have passed the status quo order in respect of the entire suit land without taking into consideration that the plaintiff's claim is only limited to Schedule B. This court also finds it very pertinent to observe that those Schedule B that have not been properly described on account of non-mentioning of the dark number in respect to the land measuring 2 bighas 2 katha 10 lecha. But the details can very well be seen from a perusal of paragraph number 8 of the plaint. Under such circumstances, this court directs that the status quo order which has been passed by the learned trial court as regards alienation and transfer shall be limited only to the Schedule B property, B land, and read with the details which have been given in paragraph number 8 of the plaint. This court further finds it very relevant to take note of that by way of that order, by way of the injunction, by way of that order, impugned order, by way of the impugned order, as well as the order passed by this court. There is a restraint on the exercise of the rights of the appellant. Under such circumstances, this court would request the learned trial court to make necessary arrangements in to make necessary to take appropriate measures to arrange the business of the court in such a manner that the instant suit can be disposed of at the earliest and preferably within a period of 1 year from the date of the instant order. With the above, the instant appeal stands disposed. I and
So court may I please, Your Lord.
Hmm.
The appellant is the defendant, Your Lord.
Hmm.
The respondent filed suit for specific performance of contract.
Hmm.
It was decreed. Thereafter, the appellant prepared an appeal. There was delay. The delay condonation application was dismissed. So the appellant could have taken it. Yes, in the
Suit for specific performance,
of contract.
suit was decreed.
Decreed.
And
And I prepared appeal. There was delay.
there was a delay.
My
Delay of how much?
delay actually here not mention the specific days, Your Lordship, but in my calculation, 88 days delay.
How much?
88 days.
When did you file the suit? Appeal.
Appeal, I filed, Lordship. Inadvertently, Lordship, my application for condonation of delay, I could not enable. But I have submitted copy. And in the
When was the judgment and decree passed?
Lord,
17/12/2019.
yes, Your Lord.
You could have filed the appeal by 18/1/2020.
I filed 2010-2010.
Huh?
2010-2010.
So how much is the delay?
Lordship,
2010 to so that period is not counted.
certified copy, there was, I applied after 30 days, after 28 days.
Why
I
did you
received.
delay?
And I, due to illness, I have stated Lordship in my application. And Your Lordship, the suit was time barred. That was not also considered.
So what is your substantial question of law?
Lordship,
Where is it?
this is before Your Lordship,
Page.
index.
What index business?
Lordship, it is
Be in the index.
take before
Huh?
the index page, Your Lord. It is
There's
take
no
like
index
this.
business.
I thought take this out.
Huh?
Top of the appeal memo, Your Lord. Before
No,
index,
First of all, Mr. Tom,
Lord.
it is ever heard of you. The first substantial questions of law has to be a part of the appeal.
memo web.
Then Where is the sale deed? Agreement for sale?
Agreement.
Where is the trial court judgment?
Trial. Page 22 start.
Where is the limitation point?
It was discussed in issue number
1.
1, page 29, Your Lord.
What was that? The plaintiff contention is that the defendant number 1 took rupees 1 lakh from him and the defendant number 2 can executed an unregistered binomial. Defendant number 2,
Another case was filed by that defendant number 2 from the same sale detail.
filed a title suit against the defendant number 1
I am
within
the
the
defendant
period of
number 1.
limitation and when the plaintiff was impeached as the pro forma defendant. When was the decree passed in that judgment?
In that judgment, 11/9/2012. Thereafter, appeal was
The
preferred.
instant appeal is admitted. Third, Mr. A.R. Soon, the learned counsel appearing on behalf of Appellate. This is an appeal under section 100 of the Code of Civil Procedure 1908. Challenging the judgment and decree passed by the learned trial court dated 17/12/2019 in title suit number 199 of 2012, which stood confirmed on account of the dismissal of the appeal filed there against on the ground of limitation, on the ground that the appeal filed was barred by limitation. The instant appeal is admitted by formulating the following questions of law. Whether the learned first appellate trial court was justified in declaring the suit in favor of the plaintiff, suit for specific performance in favor of the plaintiff. Whether section 54, article 54 of the schedule to the Limitation Act 1963 was taken into consideration in the proper perspective in decreeing the suit for specific performance of an agreement for sale dated 29/2004 when the suit was filed in the year 2012. Number two, whether the non-consideration I'm naming the second only that I can decide that with the other party coming, then remit it back to the trial.
Sure.
First appeal.
Yes.
Whether the learned first appellate court were justified, whether the judgment, the order passed by the learned first appellate court dated 3/2/2004 in Mizze case number 32/20 suffers from perversity on not taking into account the medical evidence which were duly produced before the learned first appellate court, seeking condonation of explaining sufficient cause for condoning the delete. Issue notice upon the respondent. Steps be taken by way of registered as well as usual. Within 7 days, the registry shall call for the records and the list the appeal immediately on completion of service and receipt of the records. This is an application under Order 41, Rule 5 of the Code of Civil Procedure 1908 for stay of the execution, case number 6/2020, which has been filed pursuant to the judgment and decree passed by the learned trial court dated 17/12/2019 in title suit number 199/2012. Mr. A.R. Shom, the learned counsel appearing on behalf of the appellant, submitted that if the execution proceedings are not stayed, the loss which will be occasioned to the applicant would be paramount, and the same cannot be later on substituted by any decree of the court. This court, having also taken note of that the appeal has been admitted by formulating the substantial question of law, is of the opinion that the judgment and that the title execution case number 6 of 2020 is required to be stayed pending disposal of the appeal. I stand. And accordingly, the title suit execution pending before the court of
Punchim number one, no doubt.
stand state till the disposal of the appeal.
Obliged.
Wait, little. The second appeal against concurrent ethics. The kind of the judgment of the trial court, page number 52.
Where is the substantial question of law?
Substantial question of law, my daughter 12A.
Page
Page 12A.
12. Yes, what is your case?
Yes.
You are the plaintiff.
I am the defendant. I don't think cases like this. I thought one Tahir Poroman at Bongpul, they were the original Pattatar. The plaintiff were the respondent. They are the legal layers of Tahir Poroman. So their story is that Tahir Poromani got Bongpul, he relinquished
They
his
are related.
Yeah.
Mokpul Hussain and Tahir
No.
Poromani.
So Bongpul Hussain relinquished his share in favor of Tahir Poroman. And the
How?
They
How can
simply
one
say-
relinquish?
they simply said that his share he relinquished, he died is too late. Bongpul Hussain died is too late. Before dying, he relinquished his share in favor of Tahir Poroman.
Understood.
Yes.
Are they related?
But the plain, they are
Otherwise, how can a person relinquish? Tell me.
that is the plaintiff story, man. I'm the defense.
To therefore explain to this.
Yes.
How can there be a relinquishment? Tell me a case of relinquishment or a release if they are not co-owners. Are
Yes.
they co-owners?
Who Pattata?
Pattata is co-pattata is different. A patta may have 10%.
But they say that,
10% is not a co-pattata.
yes, but their story is that originally belonged to one Muhammad Tahir Poramanik and Mokbul Hussain. The said Mokbul Hussain died without any issue, and during his lifetime, Mokbul Hussain relinquished his share in the suit land in favor of Tahir Poramanik. That is there in the claim.
Where a joint owner.
Joint owner. But that does not specifically say, they simply say, but it originally belonged to one, but they are co-pattata. Page number 5, para number 2.
Page?
Page 5, para number 2. That is the pleaded case of the claim.
Page 5.
Page 5.
Page 15.
Page 5.
15. Page 12A is your substantial question of law. How can it be page 5?
Yes, sir. Sorry. Yes. Page 15. Yes. As the Pattadar Mokbul Hussain died without any issue at the lifetime of Pattadar Mokbul Hussain, his share property has been relinquished by Pattadar Mokbul Hussain in favor of Pattadar Tahir Poramanik, and after the death of Pattadar Mokbul Hussain, his share property has been enjoyed and possessed by Pattadar Tahir Poramanik. So that is their case. So they say that they have inherited the entire suit from their predecessor Tahir Poramanik.
Who are you?
I am the defendant, my plaintiff story is that in the year 2014, we trespassed into the suit, and that is why, my lord, they have paid for declaration of right title interest over the entire, including the share of Mokbul. Our case is that our predecessor purchased these entire suit from Tahir Poramanik and Mokbul by virtue of unregistered in the year 78. And in the year 81, there was a mutation in our book. Now, both the learned courts below, without considering the plaintiff case, the plaintiff will have to establish this case independent, without even pointing any lacuna in the story of the defense. That is clear. They put the learned courts below hammered on the case of the defendant without going into plaintiff story, that is whether they are entitled to right title interest over the entire clause of fact. So that relinquishment part has not been.
Now you have taken the entire.
We are possessing over the entire property from since 81.
But you accept that the higher Paramanic was the part owner,
Yes, yes, our story is that only.
but you purchased.
We purchased, but we could not reduce that unregistered deed.
Where about the unregistered? The unregistered deed has no value.
Yes, we could not prove. And
So, but you accept that the hard Paramanic
yes,
and
we got it right from the Tahir Permanent more.
it is an admitted case by you.
That we admit.
What do you mean?
Yes, but the thing is that plaintiff will have to establish that they are entitled to right title interest over the entire plot of land.
Understood,
including
but
the
when
share of-
against whom? Right title interest against whom?
against
you-
us, yes,
You admit that they are the predecessor is the owner.
Yes.
You claim that you have purchased that land from the plaintiff's parents or predecessor by way of an unregistered
Yes,
sale deed.
yes.
The question is by way of an unregistered sale deed, who the title be given.
Yes.
When you are admitting it, what is the requirement of the plaintiff to further prove?
They will have to establish that they have got the right also from opposition. That part they will have to independently establish. But both the learned court below did not even discuss the plaintiff case. So Lordship will kindly see the judgment of the trial court. Start from page number 32. At page number 42, if the Lordship will
Let
see.
us see your first your written statement.
Written statement minus start from page number 21, sector 2.
How much is the land?
11 bigger, 1 less.
Sold at 98 rupees.
Yes.
How is it possible?
So there has come from the cross examination that the value was more than 100. So if that be the case, if that is applied in case of a default, then the same logic would also apply in case of the relinquishment 17(1)(b) that has to be registered.
Relinquishment. Therefore, I ask, what was the document the plaintiff?
Plaintiff simply said that they have relinquished. Now,
What is the document of title the
plaintiff did not produce any document. Their document is the Jamabandi, original Jamabandi. That put the names of Wangpul Lucien and Tahir Port. So, Lord, see the appendix Page number 45. These are the documents exhibited by the plaintiff. 45.
The certified copy of the Jamabandi under Kepata number is a certified. Exhibit 2 is in whose name?
This does not reveal the year. So whatever documents they have exhibited shows the name of Tahir Paramanik and Mokul. So what that is the respect of the evidence. And also, here is a mutation in the year 1981 that there was possession man.
Did you claim adverse? Claim adverse for it? It means you admit the plaintiff is the owner. Tell me. Who is Aftan Ali and all?
They are the predecessor of defense partner.
Their names were inserted on the basis of death unregistered.
That unregistered. It says for a photo.
So, your case, you don't have a case.
So color fire is the substance.
Yes. You claim that Tahir Paramanik or whatever may be, he had handed over the possession to you or you had any right to be the heirs of Tahir Paramanik. So, but here is the case, if a person is in joint possession of a particular product, that person is no longer there. The only principle that can apply against his land is the principle of ethics, which will go to the government. The government is not a party here. So under such circumstances, the land they have claimed that it has been given to them. You admit that Tahir Paramanik and his, both of them have executed the deed of sale, unregistered deed of sale. Now the question is, by way of an unregistered deed of sale, a title can be conferred upon you. No, that's not instead.
But why not then without going into the evidence the defense? The plaintiff establish their own case. The plaintiff has not. The plaintiff are the legal heirs of only Tahir Paramanik. But regarding the portion of population which they claim they have been linked with, they have failed. Their evidence does not say that the law.
Forget about the evidence. Forget about their
The
evidence.
lower court did not appreciate that fact.
The counsel, you don't need even to look into their evidence. On the basis of admissions made in your written statement, the proof could have been received. Even without the plaintiff. Order 9 Rule 8 would apply in this. This is why 2 courts are against. Because you have admitted it's never your case that you are the have adverse.
Adverse person claim was taken, but that was not considered.
They've taken that.
Yes, in the body influence judgment order. The first stated both these are contradictory and cannot be taken.
Contradictory, it can be taken.
Yes, that is there.
Look into that.
Yes.
And frame a proper question. Come back.
Well, regarding my limitation is fine. 81 my lord,
81 limitation issue is not a limitation issue. First of all, on the basis of that, any document has happened, yet it immediately
they have paid for cancellation of the limitation. This mutation, but that has not been cancelled. The mutation still exists in our case from 81. So, when there is a presumption that these entries are made genuinely. So, there must be evidence that
the presumption is what?
Presumption, my lord, that
You are in possession.
Yes. Yes. So, long position is
There is
there.
no denial. It is the suit for declaration of right title interest.
Yes.
Maybe long possession is not adverse.
But that is open.
Have you stated out there? Maybe open. Have you stated that you were adversely possessing to the interest of the owners? Or were you possessing on the basis of the two different? Only appreciate when there is a sale deed, you have got yourself your name mutated on the basis of sale deed by the predecessor of the plaintiff. Are you not claiming the title under them?
Yes.
If you are claiming the title
Yes.
under them, can you claim that your possession is adverse to the owner?
No, because that is a different. Purchase is in the year 78. Mutation is in the year 81. So
That's
perhaps
good.
to admit that the purchase, they deny to have delivered possession or they deny to have. Then also from 81, we have possession. And that possession is,
The counsel, you may have possession for 100 years.
Yes.
But it is adverse.
yes, because 81,
Adverse, it has to be against the true owner.
Yes.
So therefore, you are admitting that they are the owners.
hopefully,
See, there's a difference on this.
Yes.
You have to understand the concept of adverse possession.
yes, yes,
The concept of adverse possession is you are in possession of a land belonging to A.
that will be
And-
permissive possession.
And after being in possession out there, A had come over. He had not done anything. He was sitting out there. He knew that you were very much in possession. You were claiming all your rights over the land and also denied his title over it. And as such, you have a claim. But here is a claim where you got yourself mutated on the basis of the title being given and by the predecessor in the interest of those. Now that transference of the title is wrong. And as such, there is no title which could have passed upon you on the basis in view of the violation of Article Section 4 of the Transfer of Property Act. Now, if that transfer, but you still continue to claim the benefit on the basis of the title which is being given, thereby admitting that their predecessor were the owners and they have right to be done so. Under such a, where is your concept of adverse possession? Your possession has to be adverse to the true owner, saying that, look here, he has no building. We don't recognize. We know that he is the owner, but we don't require. We are the owner. This is how. Because you see, adverse possession, there is no equity in his favor. So your pleadings have to be such to the fact that your possession is open, hostile, and uninterrupted. You have to plead and prove that your possession is from such and such date. But you have to plead and prove that the owner very well knew that you are possessing adverse. It is your duty, not the duty of them. So where is the concept of adverse possession? We take it as
That has not been specified.
Nothing. No case. Okay.
A fact.
Told you that is the time. Fellow, at the request of Mr. Pidas,
Yes.
as thus matters and returns to be listed. A very good day, 5th of June.
Value. 43.
Yes,
Defaulter ground for the side during the pen 1 IN for vacate the stay order and for the area that we have filed a for the availability of the direction passed by as they said there are five plus five that they are not ready to
so did you deposit it?
for the
So there is
there
an
was no
apparent violation.
But-
Isn't that an apparent violation?
there was
If they are not receiving,
But-
arrear and forget, now are you deposit?
no educate
So,
on the
On that ground, it is a default.
defaulter that there is no educate that
To dispute it on that ground, you are still a defaulter. You are required to file, you deposit, that is as per sober before during the period. They filed an IA to that effect, stating that you
they
have not
filed
deposited
IA before this
before this. That look here, they are not depositing now, earlier also, now. also. You say that you are willing to deposit. They say that they are not agreeable to receive. Then what is the next course of action?
no educate on the external file and reply that I am ready to
Dismiss
pay
it on
before
that
this
ground
court
very well. Yes,
Lordship, for the last notice that we have annexed,
she can, madam, she can help you.
Good.
Let's, yes, tell me.
for the last
Last time only I was about to dismiss. Isn't it?
that there
She
was no
helped you.
Good.
Today also let her help you. Yes, come on.
we have not received rent after receipt of the decretal amount from 1st July 2017 till today. As per the last calculation, it's up to February 23, and until today, since 1st July 2017. And both the courts, Lordship, decided in our favor, and the tenant has been
On what basis? Defaulter.
Lordship.
Is it on the question of defaulter?
Yes, Your Lordship.
And
And there was a
bona fide requirement?
that has been rejected by the appellate court,
Okay.
but we are on the defaulter part. And the most importantly, the defendant himself did not adduce any evidence.
No evidence by them.
No, and defendant
Other
himself. Defendant himself.
Did not.
Tenant did not.
No.
Means you.
Yes.
No evidence.
Other
No.
person says DW1.
But other persons in the cross, they have stated that they are not well conversant with the terms of the agreement based on which the tenancy started.
Who are the other person?
Other persons, Your Lordship may kindly speak.
Some other tenant.
They are not the tenants.
No, the first
have
and
not stated-
foremost, isn't it the requirement of the tenant to come up and say, discharge the person that we are making the payment?
DW1 was Ranjit Chandra Sheel.
Who is he?
DW,
Who is he?
he himself stated that he has a saloon situated in the north of the bookstall of the defendant.
He cannot say anything. Next.
Next is
Omio Kumar Das.
Who is he?
He knows the defendant for the last 30 years. Your
No, no. Hello, madam. You have got enough. He dismissed this. Heard Ms. R. Chaudhary, the learned counsel, appearing on behalf of the petitioner. And Ms. S.
Das Gupta.
Gupta, appearing on behalf. Any further argument? No, no. This is an application under Article Section 115 of the Code of Civil Procedure 1908, challenging the judgment and decree dated 8/6/2022, passed by the learned civil judge Hailakante in title appeal number 08 of 2020, thereby affirming the judgment and decree dated 3/2/2020, passed by the learned Munsif number 1 Hailakante in title 41 of 2017. The facts leading to the instant proceeding are that the petitioner herein, the respondent herein, as plaintiff, respondent herein, who they are alive.
Yes, your lord. It is the secretary of the Barbary Project.
Okay. Respondent herein, and then you take a seat. You say something, you'll go again. Respondent herein, as plaintiff has instituted suit for eviction, for ejecting the petitioner herein, who was the defendant, from the tenanted premise, on the ground that the on the ground of defaulter in payment of rent, the said suit was registered and numbered as title suit number 41/2017. The petitioner herein, as defendant, submitted a written statement categorically admitted that on account of a sudden increase in the house rent, the defendant did not pay the monthly house rent and became a defaulter. It is very pertinent to observe that there is no mention whatsoever that the defendant thereupon approached the court under Section 5(4) of the Assam Urban Area Rent Control Act 1972, for short the Act of 1972, for depositing the rent in the court in the manner provided therein. On the basis of the said pleading, as many as six issues were framed. Issue number 2 related to whether the defendant was a defaulter in payment of rent, and the issue number 5 was an issue pertaining to whether the plaintiff had bona fide requirement of the suit premises. It is very pertinent to mention that the defendant, who was the tenant, did not adduce any evidence except it did not adduce himself as an evidence. It did not adduce, did not depose before the court or adduce evidence to the effect that he was not a defaulter. On the other hand, on behalf of the defendant, there were two other witnesses who deposed, which had nothing, which also categorically mentioned that they were not conversant with the agreement between the plaintiff and the defendant. The learned trial court, by the judgment and decree dated 3/2/2020, decreed the suit in favor of the plaintiff by holding that the defendant was a defaulter, and accordingly also directed realization of an amount of rupees 21,280 . Accordingly, the learned trial court held that the plaintiff was entitled to get possession of the suit, land or house.
Rent, it is a shop, your
Premise. By evicting the defendant, being agreed, an appeal was prepared by the defendant, which was registered and numbered as title appeal number 8/2020. The learned first appellate court duly framed 4 points for determination the appeal was dismissed by upholding the determinations were made by the learned trial court in respect to the defendant being a defaulter in payment of rent. The said judgment and decree was passed on 8/6/2022, and thereupon the instant proceedings have been filed under section 115 of the code, challenging the said judgment and decree passed by the learned first appellate court. This court have duly heard the learned counsels appearing on behalf of the parties and have given anxious consideration to their respective submissions. There is no, it is well settled. Now, from the very written statement filed by the defendant, it's clear that the defendant had himself admitted that he was a defaulter in payment of rent. It is also very clear that the defendant never took the recourse of depositing the rent before the court, which would have otherwise provided as a shield against an eviction to be carried out under section 51E of the Act of 1970. The tenant further did not depose or produce any document to show that he was not a defaulter, inasmuch as it is also well settled that it is the burden on the part of the tenant to prove that he is not a defaulter. Under such circumstances, this court is of the opinion that both the learned courts below were justified in coming to the conclusion that the defendant was a defaulter in payment of rent. The revision application, therefore, being devoid of any merits in view of the fact that there is no jurisdictional error committed by the courts below, or the exercise of jurisdiction was in any manner exercised illegally or with material irregularity, this court finds no ground to interfere with the order dated 8/6/2020, judgment and decree dated 8/6/2022. Accordingly, the instant petition stands dismissed with cost quantified at rupees 15,000. In addition to that, the appellant hearing, the plaintiff would be entitled to the cost throughout the nothing remains. The taking into I cannot take it. But, you filed the I cannot take it. Heard Ms. S. Gupta, the learned counsel, appearing on behalf of the petitioner applicant, and Ms. R. Chaudhary appearing on behalf of the opposite party. This is an application for vacating the order dated 23/8/2022 passed by this court. Taking into account that the accompanying petition revision application under section 115 has already been dismissed, the order dated 23/8/2022 no longer survives. Accordingly, the I stands closed. You could have got this order on 34/2022. 24. You got this order now. Yes. No. Absolutely no. This type of litigation, you have already, all these years, you have unnecessarily. One has to be very strict with these landlord-tenant matters. But that doesn't mean that the councils keep mentioning these landlord-tenant matters before me. We make it 10, 11,000. 11, not 15, 11. No, that I've stopped. There was in one case, the lawyer has taken this court for a ride. So from then, what they did is 6 months I gave it, asking him to come up with that undertaking. He did not give an undertaking. What he did, he clandestinely entered into an agreement with one of the decree holders and said that I have handed it over to him, and again got an agreement done in his favor, and now not in his favor, in favor of somebody else. And then this has happened. So then from then onwards, I stopped giving this 6 months or 2 months or 3 months. So what if we let them go and execute, show you out?
Outside.
May please, your lordship. Item 44 and 45, your lordship, to be taken up together. These matters is related to the similar matters which you
Oh, that same order.
same
Item 40.
44 and 45.
Okay, we picked the same date.
Okay, that matter is already disposed, your lord.
Which one? No. I remember that. This is the order 6 rule 17.
Lordship, they have filed an application for amendment of the.
And then without stating anything,
Lord.
what was the amendment required? I remember that. So in those cases, there was a stay, na?
22nd of May, next date has been fixed.
It will be. Where's the other side? Yes. Mr. K. Bhatt, finally come this side. Let you appear for PTC.
Oh, my lord, they have standing counsel.
Who is there?
I can inform them, my lord.
Kindly inform them at 2. Bring them.
44, 45.
44. And you appear for the other side. There's another state of Assam is also a part. Okay?
Okay.
We'll dispose it of. Just get hold of any of them. Either Mr. P. Nayak is there, na? PTC, I think P. Nayak is there.
So some of them.
You know, some. Very well. Get hold of anybody at 2 o'clock.
Wait, with the lord. The transfer petition
Transfer from where to where?
from Punitpur to Nokam.
Why? What matter?
My lord, Divorce.
Who need poor?
Yes, they put to know.
Why?
Basically, my lord, the petitioner is quite that they got married in the year 2013. After living for a month or so, there are some cases of domestic violence, and then they lodged an FIR. Against that, my lord, that FIR was registered as a CR case. That CR case got transferred to case court. There, my lord, his husband got convicted, but subsequently in the appeal, it was set aside. But subsequently in 2016, the petitioner, he filed two cases, one under 125 and domestic violence case. 125 case, they appeared in Nogao. They appeared and filed written statement, but subsequently in the domestic violence case, she got an order of maintenance, so she did not pursue the 125 case, and this domestic violence case was contested by both the parties in Nogao. Thereafter, my lord, subsequently it was dismissed, but then she again has preferred an appeal in Nogao. Now, the thing is that the petitioner, my lord, is a junior advocate. She is
Oh,
suffered
petitioner is an advocate.
junior advocate, new
So she has good
she is
what is no they are dismissed.
he is surviving only on maintenance provided by the husband. That is why maintenance order was passed. But my humble submission is that since they are already appearing in Nogao, contesting the cases, so from balance of confidence,
You want the transfer from where?
from Tezpur, Sonitpur to Nogao.
Where are you reside?
Nogao.
So you should not appear in that because you are also the lawyer in Noga. Go to Khunit.
So it is a Tripodi family. No,
Where?
it is a
There is no family court. They are all district judges.
family.
Dismissed. Likhit, huh? Have you filed your written statement?
No.
File your written statement. Fixing it on 1/7 before the trial court. 1/7 or will 7 or 7/7. Stay. We are vacating the stay. There is a stay.
Yes, stay with
The stay is vacated and file your.
it is a minor child.
Huh?
That is a minor child. But from balance confidence perspective, it's very difficult for her to travel to Sonitpur. And since they are already contesting cases in Nogao, so it will not be too inconvenient for them to contest votes also in Nogao. Since the law sets the is that confidence the wife be taken into account in transfer case.
There are many judgments also against.
I can place some judgment.
I can place 3 judges.
If it's
I will say that that judgment is not there. There are 3 judgments of the Supreme Court of Justice A.K. Goyal.
that it right.
You are a working lady,
Newly just joined. As by the
30 years old.
yes, but that is why my
What is your age? No, your age.
Fine.
You as a lawyer,
30.
30. How many years you have practiced? 5 years. How much?
Years.
You are now 2 years. By 35, many of the lawyers have almost how much? 10 years? 10 years practice? Yeah. No problem. And you can appear to your lawyer.
You will have to produce the evidence as well.
Right?
You will have to produce the evidence to appear there. What is what?
Hello, you have spoiled more time. 10,000 we put as cost upon you. You're getting maintained. And you will be at liberty to ask for money. For and what do you do?
Police person, constable.
There you come. One is the lawyer and the other is the itu transfer itu Nogao to transfer it. And there what seven
For it,
filing and it will also mention that the district so you will be able to appear to his lawyer except on the days you file your date on 31 7/7.
Highly offensive.
Being item 45 and 46.
It is supposed to have been done with that order. What is the next date fixed before the trial court?
22nd of May.
We have a copy of the eight Buragon. Eight Buragon and Mr. KK was appearing.
Appealing for Pindar.
Huh?
I'm appealing for the state of Assam.
Like,
Yes,
Your Lordship, I have taken steps in this case.
you've taken steps by way of the stay.
Yeah,
You have not filed your affidavit of service.
Your Honor, I have filed affidavit.
When?
8 on 8/5.
8/5.
Yes. But the
It has been-
respondent was absent at it.
It has been submitted by the learned counsel appearing on behalf of the petitioner that the affidavit of service have been filed on 8/5/2024. However, the state affidavit of service is not on record. List the matter again on 3rd of June 2024. Interim order partially.
51. It was time it just was granted by the trial court on if the prosecuted court had is prima facie that but for the rejected the injunction ground that for page 70 had
Yes.
page 70 the last had that it's the right for one of the six of the contract is that the six are by the part
The appeal was allowed.
Yes.
You are
Not-
challenging that.
Yes.
What is the interim order part?
It-
Is the next date, return
Yes.
to date, date the operation of the order part? It's the-
it's
that
a pen-
then suspended.
so my
Huh?
injunction is active
How?
trial court injunction order
How? How is it possible?
that order is passed by the trial court.
Absolutely no. Because the trial court's injunction has already merged with the appellate court's injunction. If you suspend the appellate court's order, the trial court's order doesn't remain. One has to restore the order. As of now, you don't have an injunction. We clarify it.
But on what grounds the injunction was rejected?
What happened to the respondent? Why they are not?
Date of the right.
The
15
names have
after
been shown.
subject
Respondents
is waiting side.
Who?
The first draft. Yeah.
Hey.
15 after
petitioner is presented however, the response is not to the above to be listed again on 10th of June 2024 in time of you need to get an injunction. Luckily, one thing has happened on 6/5/2024. I did not extend. Therefore, the learned counsel appearing on behalf of the petitioner submits that on 6/5/2024, this court did not extend the interim order dated 4/10/2023. It submits that if the interim order is not extended, interim order, if the status quo order which was passed by the learned trial court, what was the order passed by the learned trial court?
That is page 17.
Oh, you are appearing?
My lord.
Okay, now tell me. Argue. But
Page 78.
you are the plate.
Sir.
It is good for.
I did prayer for
It is for. MJ is what?
Annexure 1, page 70, the plain
What is good for?
I for degree of confirmation of overviewed A favor the past degree of permanent restraint for their servant from A because and cost of the along with that I have filed my injunction.
Principal dependents are these. How is your suit maintainable against phone number 6 and 7? Did you take steps under section 80?
80 if the people
The separate application. Then,
that for the injunction
as a degree for confirmation of possession of schedule 8, as a degree for confirmation. You don't have title.
like the party
How? It's a government land. Why you are not asking for declaration of your right title interest? So annual patta also. Patta is what? Patta is a document here with a title. As held by this court in various judgment, it is also a hereditary confers the title. The suit is for decree for confirmation of possession. Then an annual patta remains till it is not been cancelled. Then how is your suit maintainable? Patta issued in your name. Where?
I stated
Then what did the trial court do?
granted expertise and
To the effect, it allowed and an ex parte injunction is granted with the next restraining the DM from evicting the man. You are asking the injunction from the defendant number 6.
lordship from the defendant or
No. What was the order passed?
page 71
Page 46.
40 expertise ex parte injunctive granted the next day, thereby restraining the opposite party defendant number 6 from evicting the petition. The private defendant got with the help of opposite party number 6 defendant.
But your injunction is not against the other people. You are only asking against the defendant number 6. And how could the court have passed that order?
And also restrain the opposite party's defendant from entering into the that party.
Now, how can there be an injunction against the opposite party number 6 ex parte?
As the entire partner can shortly keep the defendant evict the plaintiff cancel my entire partner.
Cancel the annual patta, they can very well do.
So that part was also there and find that
Hence, considering the facts and data, I find it expedient to restrain the opposite party from entering into and also restrain the opposite party number from dispossessing the petitioner from the suit land till the disposal. Now, has your patta been cancelled? Then why are you asking an injunction against the respondent number 6? What is the allegation? Let's see.
if the defendant entered to the take the benefit that they came into position thereafter.
Now, why you are alleging has again orally called for the plaintiff through the lawyer, but the plaintiff verbally informed the government that they would not approach the server without any written notice. So, Iman already threatened the so-and-so and Iman here, and if the plaintiff fails to approach him, finding no alternative, the plaintiff approached the circle officer, had locked the door of his room to his peon and forcefully took signature of the plaintiff over blank papers and directed the plaintiff to vacate the suit land within 24 hours. Otherwise, he would compel to evict the plaintiff to police. So the plaintiff compelled to institute his suit along with the petition under Order 39, Rule 1 and 2.
That is just a bit.
How does the trial first appellate court look at it?
Trial court first call the principle of law in favor of the
Yes,
Yes, please, Lord.
order of the appellate court is wrong.
My lord.
Order of the appellate court is wrong.
Second, probably
In a
the
suit for possession,
Okay.
the question out there is once you produce the prima facie case and balance of convenience, the irreparable loss is always taken care of. That's the law. Here he The learned first appellate court duly confirmed the question of prima facie case. Yes, he has. Irreparable balance of convenience. Yes, it is. And then says that if he is dispossessed, he can very well amend the claim. Is it permitted?
Once the matter is sub judice, then position should be status quo should be maintained. That is good. Otherwise, here we are going dictate, and they will also proceed in some way. Court will proceed.
You claim to be in possession.
They are claiming that they are.
You claim to be in possession.
If status quo is maintained, then it will.
So let the status quo be maintained as regards possession with the disposal of. And what does the government?
Lord.
The serious allegation is being made against the circle of.
The false statement, Lordship, here government land is under the AP patta land.
Huh?
The annual patta land. It is annual land under the annual patta land. See? Once we call the plaintiff to the circle officer, but it is not correct that we have retaining them. It is not correct, Lordship. It is a false statement. Only that ground we have made a party.
This is an application under Article 227 of the Constitution challenging the order dated 23/8/2022 passed in challenging the order dated 19/9/2023 passed in Miss Appeal number 9 of the 2022, whereby the learned first appellate court set aside the injunction so granted by the learned trial court in its order dated 23/8/2022 passed in Ms. J case number 73 of the 2022, arising out of title suit number 73 over title suit number
64 of the 2020.
huh?
64 of the 2020.
54 of 2022. 64 of 2022. I've heard Ms. R. Chaudhary, the learned counsel, appearing on behalf of the petitioner, Mr. A. Alam, appearing on behalf of the private respondent, and Mr. T. A. Bhuya,
T.R. Gogoi.
T.R. Gogoi, appearing on behalf of the state respondent. The question which arises is that whether the learned first appellate court had exercised the jurisdiction not conferred upon it by law, or had exercised the jurisdiction illegally and with material irregularity. For deciding the said aspect of the matter, this court briefly would like to take note of the facts leading to the filing of the instant proceedings. The petitioner herein, as plaintiff, has instituted a suit against the against the respondents, private respondents herein, as well as the state respondent, seeking a decree for confirmation of possession and for permanent injunction. A perusal of the plain of the said suit, which have been registered and numbered as suit number 64 of the 2022, reveals that the plaintiff claimed claims their rights upon the suit land on the basis of an annual patta. It is the specific case of the plaintiff that the defendants, who have no right over the suit land, are trying to dispossess the plaintiff from the suit land. And in that process, have taken the help of the circle officer, Lahoriga, the revenue circle, and the said circle officer was threatening the petitioner, the plaintiffs, of dire consequences. And it is on the basis thereof the suit was filed seeking the relief as aforesaid stated. Along with the said suit, an injunction application was filed which was registered and numbered as Ms. case number 73 of 2022 seeking an ad interim temporary injunction restraining the opposite party, number 6, to evict the plaintiff from the suit land, as well as also the other opposite parties from entering into the suit land till the disposal of the suit. The learned trial court, by an order dated 23/5/2022, had passed an ex parte on the injunction restraining the circle officer, the defendant number 6 in the suit, from evicting the plaintiff from the suit land, and also restraining the opposite parties from entering into the suit land. Thereupon, written objections were filed by the opposite parties, stating inter alia that they were in possession of the suit land, and therefore the question did not arise of the opposite parties dispossessing the plaintiff. Isn't that, Mr. Arab, that you are in possession? By the opposite party of the defendant, stating that the opposite party of the defendants were in possession of the land, and as such, the question of granting an injunction not to dispossess the plaintiff from the suit land did not arise. Be that as it may, the learned trial court, by the detailed order dated 23/8/2022, but considering the well-settled principles of law for grant of an injunction, restrained the opposite party from entering into the suit land, and also restrained the opposite party number 6 from dispossessing the petitioners from the suit land till the disposal of the cited suit. Being agreed, an appeal was prepared by the private respondents herein, challenging the order dated 23/8/2022, passed in Ms. case number 73 of 2022. The said appeal was allowed by an order dated 19/9/2023, and it is under such circumstances the instant proceedings have been filed. This court have duly heard the learned counsels appearing on behalf of the parties and have also given due consideration to the respective submissions. This court have also perused the impugned order dated 19/9/2023. A perusal of the impugned order reveals that the learned first appellate court was in conformity with the judgment of the order passed by the learned trial court in respect to the fact that the petitioner, the plaintiff, had a prima facie case, and also the balance of convenience was in favor of the plaintiff. However, on the question of irreparable loss, harm, and injury, the learned trial court, the first appellate court, decided against the plaintiff, holding inter alia that if during the pendency of the suit the plaintiffs are dispossessed, they can very well file an amended claim. In the opinion of this court, the said observations were made by the learned first appellate court is on the face of it contrary to the well-settled principles of law. This court finds it very pertinent at this stage to observe that the power conferred upon the appellate court in an injunction proceeding is a circumscribed and limited power, and the same can be only interfered with if the order on the face of it was irrational, illegal, unreasonable, arbitrary, and was in violation to the well-settled principles for the grant of injunction. In the instant case, the learned trial court would have the learned first appellate court, taking into account the respective contentions, ought to have passed an order of status quo as regards the possession, in view of the fact that the plaintiffs as well as the opposite parties duly claimed that they were in possession of the suit land. However, on the ground of their on the aspect of irreparable loss, harm, and injury, on the aspect of it, the learned first appellate court have held that the plaintiff did not make out the case for grant of an injunction. In the opinion of this court, the said order suffers from error, jurisdictional error, and also the impugn order dated 19/9/2023 has been passed by illegally and with material have and also the jurisdictions who exercised in passing the impugn order dated 19/9/2023 also suffered from illegality as well as with material irregularity. Consequently, the impugn order dated 19/9/2023 passed in Misappeal number 9 of 2022 then set aside and quashed. And the order passed by the learned trial court stands restored. This court, however, finds it very pertinent to take note of that both the parties having claimed that to remain in possession and the learned trial court is yet to adjudicate as to who is actually in possession. The learned trial court ought to have exercised the powers under Order 39, Rule 7 of the court, or ought to have directed and thereupon directed past appropriate orders, or ought to have directed the parties to maintain status quo as regards the possession. However, the learned trial court did not do so, and thereby debarred the opposite parties from entering into the possession without coming to a final decision as to whether the opposite parties were actually in possession or not. Taking into account the above, this court directs the parties herein, parties entitled to number so and so, to maintain status quo as regards the possession till the disposal of the suit. It may, however, be open to the parties to approach the learned trial court by filing an application under Order 39, Rule 7 of the court for the purpose of inspection if deemed fit. Yes. You want to argue by yourself?
Yes.
Tell me. Okay.
The petitioner in fact, is
Okay.
son of the late monk,
Hmm?
son of late monk.
Very well. No need to son you are. The question is, you want to argue? You want to argue. We'll fix this matter for hearing. We'll fix this matter for hearing. When do you want it?
Yes.
Tell me. Let's see what are the substantial questions of law. Heard in law in directing the learned trial court to draw a preliminary decree without remanding the case to the trial. What was the case for? Suit for?
Suit was for partition and recovery of assets.
Partition.
Yeah, it was partly allowed in favor of the daughter because the plaintiff number one, her marriage to Mangsudhar was declared to be void because they were in prohibited relationship. They were cousins.
And the property belonged to what? What was the property?
It,
Partition sought for what property?
one katha, 10 lesas of land along with Assam type.
So, how does the preliminary decree come in?
Because for partition, my judgment.
Huh?
My lord, the first appellate court, so lordship would see the judgment of the first appellate court, internal page 9 of the first
Page
appellate,
9.
internal page 9 of the first appellate court judgment.
Yeah.
Says, having found all the issues,
Page.
internal page number 9.
There is no page number 9 in business law. Where is the appellate court judgment?
My lord, the certified copy that I have, my lord, there in the internal page number 9 of the judgment. The last page of the first.
Don't have any.
Page number 39 of the memo. Ask that one paragraph.
Where is the plain?
Plain, my lord.
Who are you?
I am the son of this monk.
You are a party here.
Yes, he's party man. My lord, the respondent number 1, 2, and 3. 1 is the first wife, and 2 and 3 are the sons.
Who is Ratnadhar?
Ratnadar is the cousin sister of monk, and he tried to
You are the respondent. You are the defendant.
No, I am the applicant.
What do you argue?
They were the defendants. The suit was filed by us.
Suit was filed. Ratnadhar and Chachaladhar.
Yes.
And Himadri Dhar, Hitarthi Dhar, and Hinadhar. You are
my
you are the son.
son of Himad.
So this is the respondent number 1, 2, and 3, my lord. They are the.
Where is the substitution done? How are you appearing? Your name is what? Hitartha.
No, Himad.
Oh, you are Himadri.
Himad.
You are the son of Mangshu Sekardhar. Now tell me, if the suit is for partition of a land, where is the preliminary decree?
Order 20 rule 18.
Let us see what does Order 20 Rule 18 say.
Decree in suit for partition of property or separate possession of a share therein. Where the court passes a decree for the partition of the property or for the separate possession of a share therein, then, if insofar as the decree relates to an estate assessed to the payment of revenue to the government, the decree shall declare the rights of the several parties interested in the property, but shall direct such partition or separation to be made by the collector or any gazetted subordinate of the collector deputed by him in this behalf, in accordance with such declaration with the provisions of Section 54.
So the concept of preliminary decree is not there. Preliminary decree comes under Order 20 Rule 18(2).
If insofar as such decree relates to any other immovable property or to movable property, the court may, if the partition or separation cannot be conveniently made, without further inquiry, pass a preliminary decree declaring the rights of the several parties interested in the property and giving such further direction as may be required. Yeah. So the first appellate court had clarified there, my God, that the direction was given to the collector.
Rightly?
Rightly?
No, it cannot be a preliminary decree, it's a final decree.
My lord, because there is a house over there, my lord, which part will go to
House
the...
is not the question here. What is the schedule? What's the schedule you are asking? Decree for delivery of first possession. Where is the house? There's no schedule. The schedule only doesn't say anything about the house. You're not asking for the partition of the house.
House is there.
A decree for declaration of the plaintiff's 2/5 share in the suit property as described in the schedule below.
Right.
Where's the house?
In the
Hello, we do one thing. You're not prepared to argue. You argue that matter on that next date. We'll have it on when?
sir, I have wanted to submit another evidence that the totally thought is not the daughter of the Mansur. He is the daughter of the Kanuda. The daughter thought the Kadi sister of Mansur thought tried to grave our land by using false document in placing in court in the court.
Those are Mr. Petitioner in person or appellant in person. These are things this court is not going to take. This court is only going to look into the judgment which has been passed by the first appellate court, the trial court, and the materials which are before the court. And it will be subject to the questions of law which have been already formulated. I am not going to take I'm telling you, today I am in a very good mood, and as such I am in a very nicely, I'm telling you, and you are appearing for the first time. This court is not going to look. It has to do it. I'm only going to look into as to whether those questions of law which have been formulated by this court in 2010 duly arises in the instant appeal. Okay? I will help you out. Don't worry with that. Whatever you don't need any legal expertise on that. I'll help you out. But the only thing is, you appear on next date. We'll have it on 28. Let us have it on 28th of May. And get your authorization to appear on behalf of the other two. You can appear for the other two.
My mother is already dead.
Fantastic.
And my brother is already missing because The land
The other brother is
already missing,
missing.
missing, because this land
Missing from since when?
2015.
And your mother has anybody else?
No, my mother is already died in 2015. When I
Mother died. Inador. He died. And two is missing.
I'm missing due to the land is already sold out by third party. Total land.
Understood. Why is two missing?
The missing is done by the third party. My brother missing is responsible for third party. Third party also to purchase
Missing since when?
2015, when the land is already purchased by other party.
Have you filed an FIR?
Yes,
What has happened?
there is 3 number of days in pending. It was pending in session book. Case number 183 of the 90 and another 980 of 2019.
Okay. You have the death certificate?
Yes.
And how many sons and daughters were there of Mr.
Only I have 2 brothers.
You and
My brother.
you and Gita Todhor?
Yes.
It has been submitted by the appellant, number 1. That the appellant number 3 had expired in the year 2015. Taking into account the above, this court duly takes note of the statement also made by the appellant number 1 that the appellant number 3 is survived by the appellant number 1 and 2, and as such the estate of the appellant number 3 is duly represented. Consequently, this court therefore shall proceed with the appeal by striking out the name of the appellant number 3. First, list the matter on 28/5/2024 at the top of the list. It will be at 10:15. Be ready.
Wait. Wait. Thank you.
Await service report on response number 7. Await service report upon response number 7. The LCR having not been received, list the matter.
My Lord, I have a prayer in this.
Yeah.
The Lordship will find order dated 29/2013 in Miss Case 59 of 2013. My Lord, the order is that entire amount along with the interest to be deposited. And in terms of that, my Lord, the claimant filed an application way back in 2018. The payment has not been made yet.
So Lordship, there is a history. Actually, what happened, Lordship will peruse this case.
Order dated
My Lord, order dated 20/9/2013.
where?
My Lord, this passed in Miss Case 595. Your Lordship will find.
Yes, Betty, having heard the learned counsel appearing on behalf of the applicant is directed to deposit the entire amount sum along with interest with a raised fee within 1 month from today, shall not be released in favor of anyone until further order.
Then, my Lord, your Lordship will find the order dated 19/11/2018 in IA 3193. Another IA is there.
3193.
Order dated 19/11/2018.
1911. Yes. For permission to withdraw the amount of refund which said to have been deposited by the insurer with the registry starting is attached to the petition or subject. Then
No, my lord, after that, my lord, no, this, because of this order, the payment could not.
So Lordship, the case.
And the merit
There
of
is
the
a
case,
order, Lordship. What happened? This case, Lordship, was disposed of with an order of another case was tagged with this case, and this case was disposed of. Then we filed I Lordship 1238 of 2019.
this is workman compensation.
Yes, and it was then restored, Lordship, because the order Lordship take up I 1238 of 19, and their petition they filed because
Who is you are appearing for?
I am appearing for the claimant, respond number 1.
You were a driver.
Well,
There was an accident. Or
There is
you
an
were the driver in death. It's
I-
a case of death.
is an injury case.
So the amount has been passed to the amount.
Exactly.
The amount has not been put to challenge here.
No, my lord.
Because
There,
there is no substantial question of law
Yes,
on
yes.
that case.
exactly. And my lord,
The
there,
only question which is being challenged is as to whether the driver could have driven the private vehicle or it was a public vehicle
Yes.
with a private driving license. That's it.
Yes.
Any judgment?
yes, the lord,
We
let me
will
see.
dispose it of matter.
Lord,
I think the law is settled.
yes, law is settled, my lord. Your lordship may see this 2013.
2013 matter can't remain like this.
even we do not know
There is no point at all. Your lordship may see that paragraph 17 and 18.
2013.
7 SC 62.
Paragraph
17 and 18.
stating so and so it's evidence that in certain circumstances the insurers might take such a may be taking the insured for recovery of the cost. You are referring to which paragraph?
17 and 18. Para 19 is the answer.
But this is a case wherein it's a third party.
My lord,
The same principles apply here.
my lord, so far the driving license is concerned. My lord, he was having the driving license and they did not prove that these driving license will not hold good so far these cases. There is no
Huh?
evidence on their behalf. They did not challenge that. The first time they have taken the.
Today, I did not come prepared with my DL citation, Lordship. Lordship, correct. MSC cases, Judgment Lakshmi Narayan, two cases there, Lordship, where the Appellate Court has said that this will be different from MSC case. You may fix any date. Here it is dispose of even we want it.
The lordship may see the, my lord, judgment pass. They did not argue all that in the court. In page 11, your lordship.
There is a written statement. Not here. You have a copy of the written statement?
I put because I was not prepared for hearing this time.
Madam, those type of arguments is not there in this court.
No, Lordship, I'm not.
You are
I
not
was
prepared.
talking to-
I have not come up. It is for orders.
Yes,
These
but-
things they don't.
That's why I'm searching for this. I did not
You see, the question consideration before this court is 11 years and MFA is pending.
Huh.
One has to take note of that.
No, Lordship, that's why there is a history.
There might
of
be
it. It was dismissed.
whatever, maybe it was dismissed wrongfully, rightfully,
Huh.
whatever may be, but then also a person has been deprived of his
Huh. I-
deprived of justice as to whether he should get it or not.
Yes, that-
I'm only concerned to that.
I have the written statement.
No. You see, you have raised that at paragraph number 11, page 11.
Yes, we had used evidence.
Whatever may be, you did not use any other evidence. But the question which the learned trial court held is, look here. Here is the employee's compensation is given to the employer, to the employee oblique the workman. It is a case where you may like to take it up with the owner, whatever may be.
That is the case.
You may take it up with the owner, but you cannot deprive him because he is an employee. Forget about his driving license. He is an employee.
That is the.
When he is an employee, what is he's entitled to? We are only concerned with that. He's entitled to. You may have. That is why this judgment to Mr. Datta has rightly applied. And kindly see page that portion out there, page 5. Internal page 5, page 11.
Yes. Last
The last paragraph.
Last paragraph.
So the trial court was absolutely right to hold because here the compensation is only to be given to the employee or to the workman. They are only. There's no denial that he was not an employee.
So, that's why I talked about Lakshmidhar and Sudh case because MSc cases are in a different footing than the WC cases or EC cases as far as the contract of insurance is concerned. So, Lordship, the discussion here, that's why we have filed the appeal.
You can very well go to Supreme Court and say that the judge didn't listen to all these things about the Lakshmidhar. Okay,
We might not go, Lordship, because we have already deposited.
you're not. Anyway, we dispose.
I have the WS, but
And not necessary.
Hey,
No, you have taken that point. He said that the point was not taken, but the point
is
has been
taken.
duly taken. It is there, page 11. So point is there. But the fact is, the question of law which have been framed, it doesn't apply. Taking into account that he would be an employee oblique the workman.
but then
Yes,
we might have a right to recover it from the owner.
you have.
So Lordship will pass that judgment.
That I will say.
Yes, we will have a
Here
right.
also it is mentioned. That
Huh.
is what
Yes,
he
yes.
says.
We do not have any that they will. That's why we
No,
deposit.
You can recover it too.
Yes, but give us
Lord-
the right to recover.
Lord, I have a further prayer. In page 12, we will also find interest at the rate of 9%, it ought to have been 12%.
They have not filed any appeal, Lordship. How
That's
they
not
can-
required, my lord. I will take your lordship to your lordship
Because
judgment.
already the amount was
But here it
deposited.
is given how much? 12%.
9% they have given, but I am entitled to, my lord, 12% under the
Where,
statute.
where?
And my lord, this is
Or
covered.
12, 90. No, understood. But what is this statutory?
Yes, statutory,
12%.
12% under 4A, my lord, of the Employees Compensation Act.
4A came when? These acts keeps on changing.
Yes, but it is from earlier, right from the beginning.
So it is 12%.
12%.
Now, if it is statutory, then you can.
This is
But if it is
statutory.
discretionary, no.
Yes, I am
Nothing.
aware of that, my lord. I am supported by your lordship judgment. My lord, I am
That one,
just placing to your lordship. This, my lord,
that you need not file an appeal or a cross objection
even
if
even
it
then,
is statutory.
yes,
Following that earlier judgment in what is that?
that is by your lordship.
Future.
Yes,
Future generally.
can I
But
hand it
Lordship,
over to
we
you?
had deposited it in 2013 itself. So I think the interest if at all, because that time we had deposited with the principal amount, the interest also 4 lakh something was deposited.
No, if you have deposited that amount,
As for their petition,
if you no,
4
you
lakh
see,
21,000.
if you have already deposited, we will consider it as a deposit in terms with order 24, and accordingly the interest will cease
Yes.
with the deposit.
Yes, yes.
That way it will be. But it will be. But in addition to that, you will have to pay if it is 12 additional.
Because we
But
will be
the
recovering.
principal you have paid. So here
Not
it will.
principal. Till that time, because the principal.
Understood. Now you have to recalculate
Okay.
at 12%, but
Fine.
this 12% will be calculated.
Till that date.
No. It will be calculated from 12%, it will be there. But there will not be on the basis of principal, touching on the principal. So you now have to calculate it at 12% and deposit.
Rest of the amount.
This is an appeal under section
30.
30 of the Workmen's Compensation Act 1923. Presently, the Employees Compensation Act 1923. Challenging the order dated, the award dated 14/12/2012 in the WC case number 51/2008, whereby the learned Commissioner for Employees Compensation at Golaghat, hereinafter referred to as the Learned Tribunal, had awarded an amount of rupees 3,07,540 along with simple interest at 9% on the total amount of compensation from the date of filing of the petition till the date of realization. It was also mentioned that the appellant herein will be liable to pay the said compensation along with interest to the claimant, and the amount was directed to be deposited within 30 days from the date of the said order. This court, by an order dated 15/3/2023, admitted the instant appeal by formulating two substantial questions of law, which are reproduced hereunder. The first substantial question of law relates to as to whether the appellant insurance company would be liable if the driver was not holding a valid and effective driving license to drive the vehicle, inasmuch as the driver had a driving license which authorized him to drive private vehicle and not as paid driver. This court have duly taken note of the learned trial court, the judgment of the learned tribunal, wherein the very said aspect of the matter has been duly considered and was opined that the Employees Compensation Act 1923 did not require that the claimant is required to prove whether he had possessed any driving license, either private or profession. It was opined that the claimant was only required to prove that he was an employee oblique the workman, and thereupon the owner and the insurer are jointly and severally liable for any compensation if the accident occurs during the course of employment. In the opinion of this court, the said judgment, the said opinion rendered by the learned tribunal is in consonance with the judgment of the Supreme Court in the case of S. Iappan versus United India Insurance Company Limited and another, reported in 2013, 7 SCC, page 62. And in that regard, this court finds it very relevant to reproduce paragraph 17, 18, and 19. The analysis so employed by the Supreme Court in the said judgment, in the opinion of this court, squarely applies, inasmuch as the Employees Compensation Act 1923 only mandates as regard entitlement of compensation if there is an employer-employee relationship. Isn't that, Mr. Dutt? Employer-employee relationship.
Right.
The said aspect of the matter was duly proved on the basis of evidence, and that being a finding of fact, this court cannot take into account at this stage. Under such circumstances, in the opinion of this court, the said substantial question of law does not arise. Be that as it may, if it is a case where the petitioner herein, the appellant herein, is of the opinion that the driver did not have the license, the owner can be very well. The appellant herein would be at liberty to take appropriate steps against the owner in accordance with law. However, that would not render the above therefore answers the first substantial question of law. The second substantial question of law is which has been framed is when a fact is not in dispute, additional evidence is to be led to prove the same. In the opinion of the same, the said substantial question of law so formulated is not a substantial question of law involved in the instant appeal. Considering the above, this court and Mr. S. Dr. the learned senior counsel appearing on behalf of the appellant respondent claimant submitted that the learned trial court, learned tribunal made a mistake, committed an error in not granting the statutory interest as provided in section 4A of the Employees Compensation Act 1923, which is 12%. Rather, 9% have been awarded. Although Miss
Can I
R.T.
submit one?
Majumdar, the learned counsel appearing on behalf of the appellant, opposes the said submission on the ground that there is no cross appeal.
Not cross appeal, and moreover, the interest granted was from the date of filing petition. But injury case should be from the date the thing is adjudicated. Judgment, the date, the judgment. That is the
Yes, and that is not, let it be 12%. Let it be 9%.
because
Lord, the order is very clear from the date of filing the petition. So if you want to say it's not from the date of petition.
it should be
But
from
from the
date.
law, as your lordship knows that the 76 Supreme Court.
No,
the
no, that
lordship
is
has
from,
already-
that is different because that section 171 categorically says.
My lord, that your lordship may say that is in regard to fatal injury and this is a non-fatal injury. That difference will be there.
No, section 171 is very clear. Of the Motor Vehicles Act, it categorically says that look here, you need to file, you cannot give any interest prior to it. There is no pre-interest. It hadn't be only pendant light or future.
But here, my lord, this question will not come up because this is under Employees Compensation Act and the interest rate will be 12% from the date of filing.
Not filed. It should be from the date in injury case. In death case, it will be from the date of accident, and in injury case, it's from the date of adjudication.
At that point, your lordship has already decided. I am having that
Which one?
decision also. My lord, whether even in injury case also, your lordship has decided that will be from the date of my lord, filing the petition.
Is it in Workmen?
Yes, my lord, your lordship decision is there. But,
I only forget how many go.
my lord, that is an arguable point, but that since the decision is there, my lord, I am taking to your lordship.
On the other hand, Ms. R.T. Majumdar, the learned counsel appearing on behalf of the appellant, submitted that this aspect ought to have been challenged by filing a cross appeal, which have not been done in the instant, by filing a cross objection, which have not been done in the instant case. So this court, at this stage, give me the future generally judgment.
Yes. Paragraph 27, your lordship. Paragraph 27.
And what is the power? Can you give me the act? Because there is the just compensation. Whether the same
In
language is employed.
MVX, it is a just compensation.
Here,
My lord, it is the language is not in that manner.
then how do you bring
And my
in?
lord, your lordship judgment in this WC case is also in regard to interest. This is the
No,
distinction.
that is different, but I'm on that.
My lord.
The 4A lordship,
4A.
compensation to be paid when due and penalty for default.
That it does bring. Yeah. Or at a higher rate not exceeding the maximum of the lending rate. I think that means illegal itu lakukan tu. No, I can't do that, Mr. Doctor. This is, I can only do it on the question of substantial question of law is there. That is, I can't frame I have to frame a substantial question of law. And that too has to be on the basis of appeal or cross appeal. This is a different thing. That provision doesn't say anything about just. Can't help you.
Taking recourse to order 42 rule 33.
That is why I say, you see, this section does not say anything about. I wanted to take order 41 rule 33.
Right.
But section 30 does not say give this court anything else. That
Yes.
power, the flexibility is not there.
So far, that question is your lordship is right. Your lordship is very right because this is not worded that way.
Not only that, section 30 does not give the jurisdiction
Very right.
to exercise in that manner. Even doesn't say that it has to be done as per the CPC. If that word would have been then also, I could have employed order 41 rule 33.
It's all right, my lord. I leave up to you.
This court have duly considered the said aspect of the matter and taking into account the provisions of section 30. Mr. Doctor, don't make that summation. I don't want to end it like this. Don't make it.
It's all right.
9% into society. Some future date we may. Today, if I say anything, again another lawyer will come up with this thing. Like, at the end of the day, if I keep this matter will again, your
Yes.
person would be further deprived.
I understand.
Because they have already deposited. There cannot be an interest which will run because the court have, pursuant to the order passed by the court, they have deposited.
To that effect, my lord, they will be not affected at all.
No, they will be affected. You see, you are going to be affected. I'm taking up this matter on an urgent basis, taking into account that 2013
Yes.
onwards they have deposited and there would not be any accruing of interest. A person whose injury has been there, he is now being deprived of all these things.
Right. I am obliged.
So that is the reason
Yes.
why we'll have itu section 9% or 8%. Taking into account the above, this court finds no merit in the instant appeal, for which the instant appeal stands dismissed with cost
Lordship,
of
Lordship,
10,000
we have a right to, at least that much may be mentioned, that we have a right to recover it from the owner.
that I've already mentioned.
What-
That is why I quoted that paragraph. I categorically say that it is a different matter that he will be entitled. You can very well take it over with the
So
owner.
Lordship, cost won't come, Lordship, because already we deposited as soon as the appeal. was
No, no,
made.
you have filed an appeal till date he has not got the amount.
But then, Lordship, they did not file any petition in 2003. They have been hearing, Lordship. We deposited it. as per the
Petition we have
court
filed. Petition, the
order. No,
original
they filed in
petition has been
18,
there.
2018, they filed.
Maybe.
Lordship, so no cost comes.
Okay, with cost of 10,000 rupees.
Lordship, I'll humbly submit, Lordship, cost doesn't.
All appeal has cost. Cost quantified at 10,000. Have you got any cost there? No cost. Should we put that out? Cost. And
Usually, your
Highly obliged.
it is, however, made clear that the petition, before parting with the record, this court makes it clear that the dismissal of the instant appeal shall not preclude the appellant insurance company to take up the issue with the owner, the employer of the claimant, who is the respondent number.
Two.
obliged.
I'm highly obliged.
And it is also been brought to the attention of this court that the amount has already been deposited before the registry of this court pursuant to the order passed by this. Under such circumstances, the appellant herein, the claimant here, the respondent number 1, who is the claimant herein, could be at liberty to take
Withdraw.
release of the said amount by filing an application before the registry, and the registry shall on such after making proper verification and identifying the applicant and the respondent number one of the claimant, release the said amount to the respondent.
Lovely.
Time to take appropriate action in view of the office note dated 6/5/2024. List the matter for 2 months. Yes, what are you saying about 21?
Oh, my lord, actually in this case, what are the matter? We could not take step on the respondent number 21 because he has moved to another place now.
Then what to do?
My lord, may I pray for now? I have come to know here, so he is interval moved to another place. My lord, may I pray for a justice appeal? In this case, what has happened, a decree was passed in 1998 in my favor. Matter went up to Supreme Court, and it was dismissed. Thereafter, when I put it to execution, my lord, on the one hand, they filed a suit seeking a declaration that the decree is bad. On the other hand, in the executing court, they have filed an order 21 rule 19, and both have been dismissed. Here, because of the non-service of notice on one of the pro forma defendants.
Performer?
Yes, so who never contested, never filed written statement. Pending for last 5 years.
Ranjit Roy is a performer.
And it is for on this ground, they have been taking time and notice.
Yes, he's a
last 7
performer. Strike off the name.
Yes.
You are the plaintiff.
Here the plaintiff and petitioner in order 9 to 2197. Same.
Yes, ma'am.
On the one hand, order 2197, the court has said there can be two parallel ones.
This is a proceeding saying what?
There are two appeals, ma'am. One arising from 2197, one from this one. This one is 59
The
is from
records,
title.
the office note dated 6/5/2024 shows that the steps have not been taken against the respondent number 21. It is also seen that the LCR has been received. Mr. S.K. Chakravarti, the learned counsel appearing on behalf of the appellant, submits that the respondent number 21 is a performer respondent who have never contested in the suit as well as in the appeal. Considering the above, he submits that the name of the respondent number 21 may be struck off. Accordingly, the name of the respondent number 21 is struck off. The counsel for the appellant is directed to file a fresh memo of parties before the registry of this court by 16/5/2024. On the basis of the instant order as well as the fresh memo of parties, the registry shall make necessary correction of the records and also update the same in the CI. Taking into account that the LCI has been received, list the matter for hearing in its usual form. Parties are given the liberty to file appropriate applications for early dismissal. Taking into account that the respondents, the steps that it was this matter along with
58.
is
RSA number 59 of 2007.
there is already an order on 3923. for
Yeah,
listing.
that is what I said, list this matter along with. Yes, what is this? I,
Tell you have to engage in better, my lord.
what?
Tell you have to engage, sir. Not fear the people. Because my lord, earlier,
IA for what?
I am under 5 IA, my lord. 1 IA was better was for it because it was for the it. What it was 9 or for the 5. There is a no commitment by that. So it's not a good fight by the IA. And
You have filed an application for restoration
so,
of an order. It was dismissed.
5 IA, my lord. IA 286 for my lord limitation of delay for filing of substance petition.
289.
286.
Then
And file 287, that is restores no arrest file. Test file under order 4229.
the delay is 629 days,
600 yes, sir.
24 days. Why?
24. So file or not getting up. Okay, fear, good fear.
Who?
Okay. The God informed him of when he came to when he came to go to the that's the part apart. So discussion of the fear by God.
Mr. Chakraborty, you have filed your reply.
One objection I have filed, ma'am.
This is not here to the injunction, to the condonation
We
application.
have filed in 286, ma'am. On
No, 287.
on 15 to 19, ma'am.
286 is for what?
For substitution.
Substitution.
There is a delay of my lord around 4,487 days.
Yes. They say that they did not know about the case.
My lord, kindly see paragraph 2 of that.
Your objection is,
File on 15 to 19.
huh? In 286.
Yes, ma'am.
We don't have it today. We'll list it on some other day.
Well.
It has been submitted by Mr. S. K. Chakraborty that there is an objection filed in IAC Bill 286 of 2017.
17.
The registry shall, however, the said objection is not on record. The registry shall bring on record that objection and list the matter again on 27th of May 2024. Mr. Borua, I'm not concerned whether you are here or not. You make yourself available.
I'll go, my lord. Now after my lord, article suit, my lord.
No.
I'll come back on article.
It's the matter after 4 weeks.
13.
It went up 2 weeks back.
You have not taken step?
Yes, Your Honor. We have taken steps as per, on 5/11,
When?
25/11. But, we,
25/11?
uh,
No, thereafter you have not taken step.
yes, we require
The learned counsel appearing on behalf of the applicant submits that within 7 days, first steps would be taken by way of
Your Lordship,
registered as well as
meeting
usual
2 weeks back.
by, registered by as well as usual upon the respondent for one.
Right.
After completion of steps.
Office date note dated 29/54, my lord. The service of the respondent for one is complete. It will serve to the process.
Insufficient address.
That's the registered post, my lord. The second half is been served by the process server.
Notice served. What is the matter about?
My lord,
Oh,
the
land, public premises.
public premises.
The office note revealed that usual step, usual service upon the respondent number 1 is duly complete. Mr. J. Hendrick appears on behalf of the respondent number 2. Taking into account the above, in that view of the matter, the instant proceeding is admitted. Full stop. The records of Miss
6
appeal number
6 of the
Miss appeal number 6 of 2015. We call for the court of the district judge, Kamrup Metro, Guwahati, by the registry. List the matter for hearing immediately upon receipt of the reports.
18.
it could be other corporate report I have
18.
I have filed additional affidavit in support of my conduct,
What is this application?
which has not been taxed. I filed out first of
Mr. S.P. Roy, the learned counsel appearing on behalf of the applicant submits that an additional affidavit has been filed on
1/5.
1st of May 2024. However, the same additional affidavit is not recorded. It's the matter on 3rd of June 2024, along with the said addition.
It- I have structure, so the connected FAO that has already been both
This was I-2802.
zero to
The ad hoc the learned counsel appearing on behalf of the applicant submits that the instant application has become infructuous inasmuch as the connected first appeal
FAO.
FAO number 30/2022 have already been disposed. Taking into account the above, the instant application. That's closed.
Okay.
Yes. No application for substitution.
Yep.
Who died?
My vendor.
Huh?
My vendor. Owner number 3.
No, your vendor dying has no material. Who died actually in this matter?
Lordship, respondent number 3.
Then why will
In
not
injunction
you
petition,
substitute it?
they have not made in part, but importantly, here MFA got I have made in part. Or it can strike out the name of
Response number 3. Article 3. Hearing half of the appellant submits the response number 3. His name may be struck off. Taking into account the above, the name of the response number 3 is struck off at the risk of the appellant. List the appeal for admission is done. Admitted.
yes, square 2020
Two
square 2021.
against what order?
Again, injunction
What remains out there? Small matter. Injunction granted.
Let us go as per.
Then
I have purchased from my bank. And the plaintiff case is there, there is a deed of agreement in favor from pro forma respondent number 6 and 7. Finders for declaration that the stated declaration of right title interest for pro forma is the prayer of the plaintiff. Page 37.
page number
37.
you are asking for a declaration for the performer defend number 6 and 7.
Oh, it's good for specific performance. Hello.
And you want the declaration of the vendor also.
Because they
And the vendor is not asking.
they are terror. They are terror.
Understood? The vendor is not asking. Vendor has no objection.
Performer, yes.
He has no objection in the sale which have been made in our favor. So the vendor has not joined you. You want a declaration not for yourself. You want a declaration for the respondent number 6 and 7.
I had the agreement with respondent number 6 and 7, and I got the possession of the land also on the basis of agreement, and they are claiming through other bearer, that is 3, 4, and 5.
Understood. But that performer defendant respondent number 6 and 7, however, is not against the sale being made to them.
As
They
they already put out the land to my bank. As they have already put out the land to my bank.
When?
In my written statement, I have said
Prior to that, prior to the agreement.
that
my agreement was 2020.
And you have not challenged the sale deed being made by the performer respondent number 6 and 7 to their vendors.
proforma respondents are not asking it. It is the
Understood?
plaintiff
No,
only.
therefore, performer respondent number 6 and 7
They have not came for
They sold this land to you, your
my
vendors,
Yes,
and those vendors sold it to you.
Yes.
He had an agreement with the performer respondent. When was the sale being made by the performer respondent number 6 and 7 to his vendor, your vendor?
page 81 that later all the four daughters of Tawak and Korban as named above, including Gulnahar Begum, the predecessor of Proforma Dependent number 7, sold their interest to their three brothers, including dependent number Nurul Islam Bormia by a registered sale deed number 20 of 1980, much prior to his deed of execution.
Your agreement is of 2020.
2020.
Then
And sell it also 2020. October 20, sell it.
this
My
was
vendors
being
purchased-
sold by the defendant numbers 3, 4, and 5 to the plaintiff. To the defendant. But the fact remains that prior to that, performer defendant number 6 and 7 already transferred the right to 3, 4, and 5.
Their mother, Proforma dependent number 6 and 7's mother.
Sold the
they do
entire
not-
land.
So they have no right over the inherited land.
My lord, court below in the injunction, my lord, it has been considered that since both the parties are claiming possession, so only maintain status quo with regard to the suit land because it is a tribal issue.
Why
That has been-
construction? Why the construction have been status quo being granted?
No, not construction.
Yes. Kindly see the
Construction
impugn
page
order.
111.
111.
Kindly see the impugn order. It says
In the suit, both the claim possession. Possession is in question.
maintain the status quo in respect to the regarding physical topography.
That is
That
Physical
is
topography,
construction work, etc.
etc.
in any manner till disposal of so and so. That
Yeah.
what business? How did the court do it without taking into account that you have no right? Your agreement, if it is done against the person, and therefore the plaintiff's parties, the performer respondent number 6 and 7 is not joining you. They should have been your plaintiff.
we have raised point that suit is not maintained.
Hmm.
We have raised that point that Proforma dependent number 6 and 7 are not subject to the and the plaintiff is in favor of Proforma dependent number 6 praying for right to execution. It is not maintained. And after purchase, we have mutated our name over the system and thereafter construction to start.
Huh?
And we have done
Construction complete.
or if the along with this FAO, I have filed one IS that was of saying the I have
For what?
stay granted by the FAO.
There was a stay granted.
That order was stayed.
Then
That IA was they have not come for the for modification of
it's okay, but we are taking up this on the so the IA would be always dependent upon the adjudication of this. But the problem arises with you. Your suit has a problem. You first have to get the declaration that performer defendant number 6 and 7 has a ownership. And then against them, you want to seek specific performance. Long rope.
My lord, since they are also claiming that they are in possession.
You
Any
are not also
construction.
claiming.
I am also
No, is it your injunction that not to dispossess you? No. The injunction which have been granted is to maintain in respect to the suit land regarding physical topography in construction. Not to disturb the possession is not there. Anyways,
but
ಇದು
they are
कोई लिखित में है ना लिखित है phone number 3 is struck off. The counsel appearing on behalf of the appellant shall submit before the registry of this court a fresh memo party by 16th of May 2024, and on the basis thereof, necessary corrections be made by the registry in the course title as also in the CI and update the same in the CI. List the appeal for disposal on 29th on 30. Oh no, we are having a lot of matters on today's what? On 16th. On 16th of May 2020. Oh, you have to file it, you correct it by 30. You submit the memo party by 30.
Okay.
Yes, what about the service?
The respondent number 1 and 2 have filed wakalatnama.
Who are the others?
With regard to others, my lord, the respondent number 3 has, there is no service report. Oh, my lord, I'm sorry. AD card has not been received in respect of 3 and 5. 4, 7 has, and 8 have refused, my lord. And others, my lord, everything of with regard to respondent number.
The learned counsel appearing on behalf of the appellant. On behalf of the appellant.
If I may submit, all these parties have initially had proceeded ex parte in respect of all.
You want the structure tracking of the names of the other respondent number 3 to 8.
3 to 9,
My lord, also the copy of the IA has opened. The memo of it is not
IA is for what?
for stay of. Let them be directed to serve a copy. I'll serve the memo of it. I am for respondent number 1.
The learned counsel hearing on behalf of the appellant are sent to submit to the respondent number 3 to 9. Having not participated in the before the trial court, the suit and the proceedings have proceeded ex parte against them. Their names may be struck off. Taking into account the state submission, the names of the respondent number 3 to 9 in both the interest the appeal stands struck off. The counsel appearing on behalf of the appellant is directed to file a fresh memo of party before the registry of this court by 16/5/2024, and on the basis thereof, the registry shall make necessary corrections to records and also update the same SDI. Mr. So the learned counsel appearing on behalf of the respondent submits that he may be provided an extra copy of the interlocutory application being 989 of 2023. The learned counsel appearing on behalf of the applicant submits that the same would be done during the course of the day. This the matter again on this the matter on 5th of June 2024. The interim order passed in IA 989 of 2023 and extended till the next week.
Please, this is
Service not complete. What is this petition? Petition challenging what?
So they have not filed the petition on the ground of formal statement. They have put the petition record. Order it 15.
What was the stage at which it was withdrawn?
They are some defendant are filed up. They are WS matter.
Only deputy. Then what is wrong?
My lord, here, my lord, they have, my lord, suit filed in 2018, my lord. And
Huh?
amended, my lord, in 2019 already, my lord, and my lord, 2022, they have, my lord, wanted to withdraw the body, my
Okay, anyway, service is not complete.
Right.
The service being not complete, the learned counsel appearing on behalf of the applicant is directed to take fresh step by way of registered as well as usual within 7 days. This is the matter of the completion of service.
obligement.
Yes, what is it?
the 70. Take the step before lesson number 6 on 25 4.
Which order?
2020.
Huh?
By order dated 3520. As per office note dated.
Which one? No, first of all, you are asking for correction of an order you have not enclosed. Which order you are asking for correction? 3523.
This already disposed of. This one already.
So you want the correction there.
No, already done.
And what do you want?
Done.
Why the IA for?
I was disposed of.
Madam, you are asking for an IA, file an IA for correction of the title in respondent number 3 in the above case by inserting the name of the district judge Dimapur in place of deputy commissioner.
But already disposed of.
Where? Where do you want the correction? This IA, are you pressing it or not?
No, Lord.
Okay.
Already disposed of.
IA P1014 of 2023. The learned counsel appearing on behalf of the applicant, Madam, what's your name?
Emerald.
Emerald, submits that the state application is not pressed. Accordingly, the instant application stands closed on withdrawal. Yes, what is this
Lord,
modification?
during the pendency of the appeal, the matter was compromised way back on 18/8. My lord, the branch manager of the Nagaur did not inform the regional office. As a result, my lord, we were not knowing about that compromise. In the meantime, my lord, the matter was heard and Lordship passed an order. Lord, your Lordship, can you see at page 17, the compromise order?
You have earlier compromised.
My lord, at page 17, at rupees 1,70,000. And they have received this information we did not have. And ultimately, my lord, your Lordship heard it on 21/2023. And the award was, my lord, upheld by your Lordship.
Yes.
My client already received the money. Now,
The money.
Yes.
As per the award.
not as per the annexure for the compromise.
You have received the compromise.
Yes, my lord.
So then
Nothing remains survived.
this is an application by seeking modification of the judgment and order dated 21/2023 passed by this court. On the ground that prior to the judgment and order passed, the parties have already agreed into a memorandum of agreement on 18, what is the date?
18/8/2017.
2017. Mr. I.A. Talukdar, appearing on behalf of the respondent, submits that in consonance with the agreement, the applicant, the claimant have already received the consideration, the amount,
Settled amount.
the settled amount of rupees 1,70,000 in full and final settlement of every claim. So, taking into account of the above, this court and have already received the full and final settlement of the claim. So, he further submits that as the claimant have already received the said amount, the claimant would not like to further agitate the matter. Taking into account the development which was, however, not brought to the attention of this court at that relevant point of time, when the judgment and order was passed on 21/2023, this court disposes of the instant application by observing that in view of the settlement arrived on 18/8/2017, the directions to pass in the judgment and order dated 21/2023 in MFA number 123 of the 2022 of making payment of the said amount to the petitioner shall no longer be required. I
Right.
extend-
So there is a delay of 6 days in preparing the second.
Huh?
There is a delay of 6 days in preparing the second. We have already taken steps as a desk office note dated 5/1/20. Service is complete in respect of all the 5.
It is an application for condonation of delay of 6 days in filing the accompanying appeal against the judgment
Judgment and decree dated 3/4/2020.
and decree dated
3/4/2020.
2/4.
3/4.
Decree dated 3/4/2023 passed in money appeal number 1 of the 2019. So, this court have taken note of that the respondents are have already been served. So, accordingly, service is complete.
Service is
1 to 5.
1 to 5.
Accordingly, the delay of 6 days, accordingly, this court taking into account the cause shown in the application, which this court considered it to be sufficient, condones the delay of 6 days in preparing the appeal. So, I extend both the registry shall register the accompanying appeal and list it in the stage of Order 41/11 on such date as per the read.
If you
Please, your lord.
Yes, but it is.
This I for condemnation of delay of 98 days.
Huh?
This I for condemnation of delay of 98 days. Filing this. If I have taken this, that has
Mr. Counsel, you file a better additional appeal. You cannot say that your person did not know that there is an appeal provided. That cannot be allowed down. Mr. So-and-so, Devaman,
Lord.
The learned counsel appearing on behalf of the applicant submits that he may be permitted to file an additional affidavit in the matter explaining the delay. List the matter after 3 weeks. Yes, service complete.
Service
Then not yet admitted.
I am appearing for respondent of Pereira.
Corresponding.
So it has to be admitted.
Yes.
A substantial question of law. Is the matter for admission. Taking into account that the service is complete. It's the matter for admission. On when?
I thought if there is no difficulty, then any day in June.
Well, 10th of June.
Yes.
It's not
20?
dated by- Yes, my lord, both the respondent and two, the APR responding the both.
Service being complete. Service being complete and the LPR having been received. It's the matter for hearing any trivial cause.
27 of the analogous. This together.
27 also. All are appearing. Itu balik ke apa? You are appearing 27 also.
Yes, my lord.
Both are analogous.
Yes, what is this?
This is late by 23 days, my lord.
How much?
23 days. 11.
Everybody is appearing.
I'm
Delay condone. He to agor to nisna hote. Delay to condone. List it for. Yes.
Challenging in order of the special tribunal, the land grabbing act.
Ah,
In fact, it was filed as a writ petition, therefore it was converted as a CRP.
okay.
That's
Then-
how it's before law. It's the first time, right? As challenged below the judgment of order of the Lord special tribunal. That will not find at page 41.
Hmm.
Lord, I have been got help with a land grabber, and Lord, I have been asked to take compensation of
You are the land grabber.
Lord, help with a land grabber.
Then
Lord, it's like basically a dispute with them in the family matter, dispute with brothers matter. And my lord, there's a finding, my lord, that I have been, my lord, in possession of the land for 7 years, which is contrary to the evidence matter. And my lord, I have been declared as a land grabber. And my lord has been, my lord, directed to pay compensation of, my lord, 1 lakh.
has the notice not been issued here?
Not notice is not.
Okay. List the matter on. Notice has not been issued.
How is not?
It went into the question of 226 is maintainable or not. In fact, the 227 is maintainable against, taking into account that the appellate forum is not there. Okay. List the matter for motion on when?
But 22nd, 22nd of
26.
Apply. The service is complete.
Service complete.
Completed. I find the affidavit or
Service
may
complete.
not be.
What is this? What is the matter about?
Lordship, actually, I received the counter claim, Lord. I received the copy later on, Lord. So I'm being debarred from filing the document.
Huh?
I'm being debarred from filing the document.
When did you receive? Where is that order? Case record is received on transfer, peruse the case record, heard learned counsel, and remand the case is submitted for hearing. Where is that order?
I received on 2011-2023, but on 11-1-2024, Lordship,
The London magistrate has considered from the date
That
But
file
what-
counterclaim on demand and the stipulated time for filing of the counterclaim is forgot. Why?
My lord, here, this very petition itself is not maintainable. It is filed under section 115 of CPC. But the order is not the matter is not finally disposed of. And moreover, kindly tell the prayer portion. Prayer portion, it says issuance of writ. Issuance of writ. If the prayer portion of the present petition, we kindly tell you, it is all relating to issue of writ. The shows as to why the writ of nature of certiorari should not be issued.
So, Mr. Nandi, would
My
you be satisfied if I record it in the order that Mr. P. Sharma doesn't know head or tail about what is 115 and 227 and then allow the application? Do you be satisfied with that? No.
Because
Allowing to this court will do, would you be satisfied with that observation?
if the lordship kindly what about the order?
I know. The thing is that we will record it. Mr. P. Sharma doesn't know what is the difference between
It is to the lord.
115 and 227. He is advised to read section 115 properly at home. He is further advised to also read the judgment of Surya Devi properly at home and then appear in this court. We'll observe all these things. But whatever may be, the mistake is his. He has advised wrongly. Can we penalize the client on that? It's a sorry state of affairs that the client has been engaged him. That day also I got another matter.
Similar.
Similar, he keeps on doing. He's more into fisheries than doing all these things. So somehow he gets hold of some clients out here in the civil matters. He does a matter, doesn't know the difference. What is a 226, what is 227, and what is 115? He doesn't know. But the fault is who? Can the client suffer? No. I would have to said anything if there was any other the suit, but the suit was still at the stage of published.
My lord, the chances are already why the counterclaim was filed on 8/9/2023. They were present. Why they did not receive the copy? Is there any law that from the date of receipt of the
Is he the counsel there also? You are the counsel there also? Huh?
Yes, Lord. My junior was there.
Don't
I
worry.
was there.
We impose a cost on him this time. 25,000 on him. On Mr. Pisha. Not on the client. To be deposited in the registry and you take.
Was not myself, my another client, another broker. What's that?
You can't be so careless. Huh? It is the absolute case of carelessness. First of all, you don't read what is 227, what is 226, what is 150. You don't read what is Surya Devi. Supreme Court has categorically held, then the matter went to a Supreme Court, another matter. The matter went to the 3 judges bench, wherein the Supreme Court categorically held that Surya Dev Rai is wrong only to the effect that there cannot be a 226. It has to be, can be a 227 because a writ cannot be issued. Then also you have asked for a writ. So, you dismiss the petition on that basis, then you will learn or you pay the cost of 25,000. Which one?
Okay, it little lot.
No, on you, not
Okay.
on the client.
Got-
For you are a rich man, rich counsel.
No, no. But if you are a bit lower, I would say
What do you say about your fellow?
I leave it up to the
No,
law.
no. What do you think about the consideration for him?
My lord,
I
the suffering is for the
I agree perfectly.
it's we are suffering. It is my property. I have made.
That's good. So only
Type
thing
file.
is that if I keep on delaying the matter, this will be only delaying the matter.
Let it be with cost.
The cost I'll impose, the cost is on him. So what should I put? I put it to you.
My lord, as your lordship has already said, it is 25. Let it be 25.
On him. Not on his client, on him. It is, you see, he did not take. The lawyer did not take. When the lawyer does not take, it is absolutely the lawyer's mistake. Then upon one fine day, they come up out there, look here, we have not received. The requirement is when it is filed, they should be cognizant about. Which they have not. It's absolutely mistake. Now, do you want your fellow counsel to be imposed with 25,000 or little less?
It is
I
up
leave it to
up
you.
the lordship.
No, I leave it to you.
Let it be 21.
Eh?
Let it be 20.
20.
20 also. For 10 lot.
No, no, 10 is yours and 10 is his. 10 for filing this type of petition for you and 10 for your fellow friend out there in the trial court. 10, 10, 20. Now, this is an application under Section 115 of the Code of Civil Procedure 1908, challenging the order dated 11/1/2024, passed in title suit number 481/2023, whereby the learned court of the Civil Judge number 2, Senior Division, Kamrup Metro at Guwahati, had rejected the petition filed by the petitioners to file the written statement against the counterclaim. So, taking into account that the order dated 11/1/2024 is not revisable in terms with Section 115 of the code. This code, for the interest of justice, converts it to a proceedings under Article 2 to 7 of the Constitution. Next. This court have taken note of the fact that on 8/9/2023, the defendants had filed a written statement come counterclaim. The written statement come counterclaim.
Yes.
However, the written statement, however, were orders passed by the court for filing written statement.
My lord, that order places is not connected to this 8/9/2015.
However, the plaintiff did not file any written statement and filed a petition at a later stage on (11/1/2024), seeking further time for filing the written statement. This court have inquired with Mr. P. Sharma, the learned counsel appearing on behalf of the petitioner, as to why the written statement was not filed. The learned counsel submitted that the counsel appearing on behalf of the plaintiff before the trial court did not receive the written statement come counterclaim from the records.
It was not. As per his version, Lord. It was not in the record.
You say that he did not.
It was not.
And under such circumstances, the petitioners were not aware about filing of a written counterclaim. This court further finds it very pertinent to take note of. The learned counsel further submitted that the written statement to the counterclaim is ready and can be filed on such date as this court may fix. Upon hearing the learned counsel appearing on behalf of the parties, this court is of the opinion that the not filing of the written statement to the counterclaim is not the fault on the part of the plaintiff, but is on account of the negligence on part of is on account of the negligence on the part of the counsel representing the plaintiff in the suit. It being well settled that on account of the counsel, the party should not suffer. This court would not like to debar the plaintiffs from filing the written statement. Accordingly, this court interferes with the order dated 11/1/2024. Thereby permitting the plaintiffs to submit their written statement by 29th of May before the learned trial court. This court, however, is also mindful of the fact that on account of the negligence on the part of the counsels appearing on behalf of the plaintiff, the defendant, the suit, the counterclaim of the defendants have been delayed. Under such circumstances, this court is of the opinion that some cost has to be imposed for the interests of justice. Taking into account that the plaintiffs were not at fault, however, it was the fault of the counsel. This court imposes a cost of ₹20,000 upon Mr. P. Sharma, the learned counsel appearing on behalf of the petitioner, who is also the counsel before the learned trial court. The said amount be deposited by the counsel before the learned trial court on the date on which the written statement is filed, that is on 29/5/2024, is directed to be filed. It is further observed that deposit of the said amount of 20,000 shall be a condition precedent for receiving the said, for accepting the written statement to the counterclaim. In the circumstance the counsel does not deposit, the plaintiff shall deposit the said amount and thereupon recover the same from their counsels in the manner appropriate in the law, provided in the law.
I will pay lot. That part needs I pay lot.
I don't know. You never know, because I'm putting his written statement on the basis thereof. Tomorrow you don't pay. No, I'm saying you don't pay. Then the client out there would be penalized from filing the written statement. So they will have to pay. Because that is a condition precedent. They will pay, then they will recover it from you by doing whatever, moving it to the bar council or do whatever. Oh, there's a stay, na?
Yes. No.
He is not there, my
Stay is not. Next date is 15/6.
Okay, it is
Stay is
29
not
to
there.
no, 15/6.
He is
Not there, na?
not.
So we put it on 15/6. We make it 15, Mr. Sharma. 15. 1/5. Yes, review. Oh, that matter. Yes. Then adjournment. Then no review.
There is another vital aspect you are not of the impugn order.
My order.
Your lordship, that the court below order
Okay.
at page 62.
Page
62, your lordship.
of review petition.
Not review petition, in the annex
62.
62.
52.
66, your lordship.
Petition stands finished at 52. There's another. Oh, there. Yeah.
In my
62.
review,
Their
in
objection.
my CRP, civil review
Yes,
petition.
62. Yes.
Yes, this is the impugn order that is passed by the court below, your lordship. Another vital, as there are 10 adjournments as per data, but in my attention there is 11. Okay, but if your lordship keeping aside the past act, if you come to this specific date, your lordship, what steps I have done?
No, kindly see page 62.
Yes, your lordship.
That is a part of his affidavit.
No. This is the order, impugn order,
Impugn order.
based on which your
It
lordship.
is 52, madam. 52. 29/10/2022.
21/9/2022, your lordship.
Yes, that is page 49. Yes, tell me. 21/9/2020.
62, your lordship.
Of the review petition.
Or again,
Oh,
that
yes.
is why I told you.
Oh, yes, your lordship.
You are again saying another review
I'm
petition.
sorry, your lordship.
Yes, tell me.
Yes, 62, your lordship. And if this is the order, impugn order, which was passed by the court below.
Hmm.
There is another vital aspect which is not observed by the court below, is that it was the order passed based on petition number 1466 of 2022. But my petition is bearing number 1266. That is another vital aspect.
Madam, you were asked to produce the medical evidence. Do you know why?
Yes, your lordship.
Why?
Yes. That
No, madam. Kindly come to the picture. Why?
because it is
Oh, because earlier occasion you said that you were not well.
yes.
Therefore, the court says
That-
if you are saying that you are not well, to file your evidence, produce your medical certificate.
yes, your lordship.
You were supposed to produce the medical certificate on that date, then also you failed.
Yes, your lordship. So it is not my fault. It is the fault of the engaged advocate, because it's continuously he is represented in all dates. He was there.
So?
I have submitted all whatever the engaged advocate asked me. The cost also
Madam,
important.
have you taken it up with the Bar Council?
No, your lordship.
Then don't come up with all these things. Don't come up with all. I'm not going to explain.
And main thing is, your lordship,
If it is you, as a counsel, you have made the mistake, I would have definitely taken it. But you cannot blame an advocate who is there. I'm telling you.
I never blame.
You are.
I never blame.
You are blaming the
It is-
advocate out there.
It is the lapse of my engaged advocate.
That is what you are blaming that advocate. Why you are blaming that advocate? Who is there, whom you have engaged? What were you doing all this time on 10 days? 10 dates are being given to you. You are not more than entitled to more than 3 dates in a hearing. Kindly appreciate one thing.
Yes, your lordship.
It is a hearing starts from Order 18, Rule 1.
Yes, your lordship.
From the date of filing of the evidence on affidavit. You have not filed your evidence on affidavit for 10 long adjournments. 2 years have passed by. And you want a further relaxation?
Another aspect, your lordship. There is another material irregularity. Evidence was not given. That is another evidence is not yet in, your lordship.
Evidence is not there,
There, evidence not need.
not needed.
Yeah, needed. It is
needs, your lordship,
Then,
for me.
Then?
Otherwise,
in fact, the trial court was wrong in one thing. The trial court ought to have dismissed the suit right away, unless there was an admission. Have you seen the provisions of Order 17?
yes, your lordship.
What does 17.2 say? Sorry, what does Order 17.2 say? Order 17 Rule 2 says that if a person was fixed on the certain judge date, if he fails to file his evidence, the court shall proceed immediately. 17.3.
But we have no counterclaim. But they were lucky enough that this suit was not dismissed.
The suit should have been right away dismissed. You don't have a case, madam. Certain matters you have to stop somewhere. Because if I interfere with these type of things, you know what happens? The order is being taken up. And then in another case, that order just, that is called biting you back.
So there is no alternative remedy exists. Only your
I
lordship.
can't help it. This is not an order for which error apparent. Unless he gives consent. For permitting the plaintiff to adduce evidence fixed 29/10/2022 year. I've already taken 10 adjournments, and even after 10 adjournments have been granted, the plaintiff did not file his evidence on affidavit. This court duly takes note of the provisions of Order 17, Rule 1 of the court, wherein it stipulates that not only then more than 3 adjournments can be granted at the stage of it, not more than. In the instant case, the learned trial court was much lenient in granting more than what was envisaged even under the statutory regime. Under such a, this finds no jurisdictional error in the order dated so and so. According to the interim order, the court fixes the matter on so and so on which day the party shall appear before the trial court. So, in the meantime, suit has been dismissed.
No.
Get the suit dismissed, then
If
the
we do
review
not file
becomes
evidence, then it
infructuous.
will get dismissed. If we do not file evidence, then automatically it will get dismissed. It is
Don't file.
pending for DWS.
Then you save me of the trouble of not dismissing the review petition also. Then there is an order passed by the Supreme Court, no, that a review petition, once had the order having been already affected, you can't review an order. Okay. Unless he gives a concession, you go and explain to him. If he gives a concession, I'll do anything. Otherwise, he has to give a concession that the plaintiffs are, the defendants are okay of one more chance. If he gives, and I will say that it is on the concession this is happened, not otherwise. I'm not going to say anything. Then adjournment. List the matter again on 3rd of June 2024. Oh, I'm not there. On 31st of May 2024. On which date the learned counsel appearing on behalf of both the parties shall obtain instructions.
Highly obliged.
Yes,
Appellate number 1 died, my lord.
within time.
So this is a substitute in time. And legal years name are at page 9 and 10, my lord. Page 9, bottom.
It's 1A to 1G.
G, 1G, my lord.
This is appellant.
Appellate.
Sole.
Appellate number 1 died.
Appellant number 1, right? This is an application under Order 22, Rule 3 of the Code of Civil Procedure 1908 for substituting the appellant number 1 who expired on 18/10/2023. It has been submitted that it has been mentioned that the right to sue survives pursuant to the death of the appellant number 1, and the appellant number 1 is survived by the applicants in the instant application. So taking into account that they are the legal representatives of the appellant number 1, the applicants herein are the legal representative of the appellant number 1. The said applicants are substituted against the name of the appellant number 1 in the accompanying second appeal.
Yeah.
Second appeal, and they are arrayed as appellant number 1.1, 1.2, 1.3, 1.4, 1.5, 1.6, 1.7 to the accompanying second appeal. The counsel appearing on behalf of the appellant is applicants are directed to file a fresh memo of parties before the registry of this court in terms with the instant order, and the registry shall make necessary changes in the cause title and also update the same in the CIS.
Much obliged.
And the Spraco,
So I have not.
Huh?
I have not.
who filed?
Yeah, please.
What is it?
I'll. For strike out of proper defendant number 2 to 7.
Huh?
I
I have for what? Order 15, Rule 2 and 3. Order 16A, Rule 6 for striking out the proforma defendant number 2 to 7. Who are 2 to 7?
I'm representing.
Why?
I don't know. Well, I have not been served with a copy. I have seen that today. I have.
Oh, Mr. Counsel, what is this?
Lordship,
Who are you?
Lordship, I am the plaintiff in the original suit, Lordship. And in the original suit, I have filed an application, file number 564 of 2009 under Order 11, Lordship. And proforma respondent number 2,
Order?
Order 11, Rule 1, Lordship.
For what? Interrogation.
Interrogation, Lordship.
Then?
Then the proforma defendant have the contesting on that petition, Lordship. That's why I'm paying for striking out that. They are
Petition is who?
this petition, Lordship.
They are them
They are proforma defendant,
3 to 7.
Lordship.
Who are you?
I am
This is
the
the main defendant.
Understood. But who are you here to file that? Have you struck off their name from the suit?
Lordship, not from the suit, Lordship. Lordship, only from the application number 564 of 2009.
Huh?
Only with regards to 564 of 2009,
They are
Lordship.
main defendant.
I'm the main.
Main defendant.
Who?
They are.
He.
We all are the main defendants. in
They
the-
are all are
that
main
also-
defendant.
What is this IA for? This application file?
Application filed by the.
What are you challenging, Mr. Ghosh?
My lord, I am challenging the order passed by the Learned Track Court,
Dated
whereby the interrogatory dated at page
25/7/2023.
Yes.
Who filed it? Order 11, Rule 1.
is the respondent.
You are the defendant. You are the plaintiff.
Plaintiff in the original suit, Lord.
You filed it against asking the interrogatories with them,
No, not.
from them,
From
from the defendant.
From all the defendants, Lordship,
Okay, you have asked for.
asked for.
Then
But
have they replied?
they are supposed to reply, Lordship.
Then what happened?
But Lordship, respondent number 3 to 7 was not contesting that petition, Lordship.
Then?
And the respondent.
Then what did the court do?
Number 1 and 2 here.
What did the court do?
Court allowed the interrogatory.
Allowed us, Lordship, but they have challenged this.
Court allowed the interrogatories under what provision? If I remember correctly, Order 11 Rule 1 gives a right to submit interrogatory. Then it has to be in a particular form which is there in the appendix. Then they would have to reply under Order 11 Rule 6. Or that is also in terms with the form which is given in the appendix. If they don't do so, then you go under Order 11 Rule 20, isn't it? Did you file an application under Order 11 Rule 20 before the court?
Lordship, they have challenged this order. Lordship. They have challenged that order.
I'm not on that. Did you file? You wanted the interrogatories. Did you go and file an Order 11 Rule 20? How can an interrogatories be given at the first stage by the court? Can it be given? Is Order 11 Rule 1 conceived about an order being passed by the court?
But the main suit is still.
Yes.
What interrogatories they have been sought for, and that in
I'm not on that. But how did the court pass that order?
yes, that is why I am challenged.
The court can pass an order. You have to say one thing. See Order 11 Rule 20.
Where the party from whom discovery or any kind of inspection or object to the same or any part thereof, court may, if satisfied that the right to discovery or inspection or depend on the determination of any issue or question in issue, or that for any other reason it is desirable that any or question in issue should be determined before deciding upon the right of discovery or inspection, ordered that such issue or question be determined first and revert the question as to the discovery or
Then the court will pass an order.
yes.
Order 11 Rule 20.
20.
If there is no compliance to that order under Order 11 Rule 20, if it is the plaintiff, his case is struck off. If it is the defendant, his defense is struck off to that extent. Now tell me, what is this type of cases? How did the court pass an order? Did you file an application under Order 11 Rule 20 complaining that you filed, he has not replied, so give it? That is the prerequisite. Let's see what the court did.
One,
I have perused the case record in view of the rebel and find the court the question ought to be answered by the plaintiff for the ambiguity of the to put their cases quickly relevant and relating to the matter in issue, there is no ground to refuse to grant leave to the plaintiff, hence the fair mitigation. Anyways, we do one thing. We have this CRP-IO on some other day. This is absolutely not maintainable. You want to withdraw or should I dismiss? You have no business.
Lordship,
Your
kindly-
name. Your name.
MH Soikal.
Or Mr. M.S. Taker, the learned counsel appearing on behalf of the applicant, submit that he would not like to press the instant application. He, however, submits that the CRP-IO 268 of 2023 be disposed of at an early date, taking into account that he is the plaintiff in the suit and the suit have been stayed by this court. So, taking into account the IAC number 550 of 2024 and closed on withdrawal. This court have also taken note of the order dated 28/8/2023, wherein the further proceedings of petition number 27 of 2022 have been stayed Accordingly, this court fixes this matter again on 25/2024, on which date an attempt shall be made to dispose of the proceedings on the next day. Interim order passed earlier shall continue till then. Okay, interim- so, Aku itu take it to the matter if interim order passed. Yes,
But if one of the appellant expired,
where is the other side? First time. First time. Okay, notice equal to 6 weeks return of steps by register and 7 days.
Appellate.
Shape will note the shooting idea of
Hmm.
the respondent.
Delay for how many days? 884 days.
884 days. They are stating in paragraph number 3.
From the office note, it reveals that the service upon the respond numbers 1 to 10 are complete. List the matter for the end of justice, taking into account that the respondents are not represented. The matter stands adjourned to be listed again on 3rd of June 2024. So, it's the matter on 3rd of June.
Obliged, bro.
First time.
Yeah.
First time.
First time.
Okay, notice 6 weeks. Steps within
Obliged.
7 days. Registered than usual. 37 also same.
First time.
First time. Same order. Huh? Within time.
Yes. This higher.
Appellant number 10 died when?
Yes. He died on 5/12/2020. Certificate has been enclosed on
Applicant died on
5/12/2023.
23.
Yes.
And you filed this on 23. Okay.
Yes.
This is an application under order 22 for substitution of 22 rule 3 of the Code of Civil Procedure 1908 for substitution of the legal representatives of the deceased appellant number 10 who expired on 5/12/2023. Taking into account that the application has been filed within the period of limitation and further the state appeal. Further, the right to sue continues pursuant to the death of the appellant number 10. This court substitutes the legal representatives of the appellant number 10 whose names have been duly mentioned in paragraph number 2 to the instant application as appellant number 10.1, 10.2, 10.3, 10.4, 10.5 to the accompanying appeal. The counsel appearing on behalf of the appellant is directed to file a fresh memo of partition to the registry of this court. And on the basis of the instant order as well as the fresh memo of parties, the registry shall make necessary correction in the record of right, necessary corrections in the cause title, and also update the same in the CIS.
Obliged.
Within time.
Yes.
Hey, I
Number
got
30.
okay.
There are 3 I have.
Who died?
This one number 30.
Oh, notice has to be issued. Oh,
Otherwise within time.
Huh?
Within time.
within time it is not necessary. This is icon খালি বেলেগ হবো 22-3 আছে 22-4 হবে হ্যাঁ and they are and আগতো দেখিছো right to sue survive upon the right to be sued but to sue to be হলে এই paragraph কি আছে now it will be 13.1 13.2 13.4 respondent 13.1 এটা কৰিব আৰু এই এপিলত দুই of the memo parties file কৰিব আকৌ এপিলত কৰিব issue notice to the newly substituted respondent number 13.1 13.2 13.3 and 13.4 steps to be taken within 7 days by registered as well as future list the matter service.
Whole appellant.
Time within time. Full appellant right, huh? So here I got order.
Case 6 para 4.
Era
Para 4 maro case 6.
era puro tate appellant number এতিয়া হ'ব 1.1 of the 1.8 1.1 of the 1.8
Of the
first time
First, my lord, they have appeared matter. My lord, they have filed an appeal matter. Against that, we have filed cross objection matter. There is a delay in filing the cross appeal. 22
cross objection delay
22 days.
why is it required
My lord, my right title was declared in respect of
understood cross objection why do you require under section 5 abandon you require
not required.
order 41 will 22 says as the court may deem I deem fit I don't deem fit
Have to apply.
you do one thing we admit the cross appeal cross objection second appeal second then you have to have a substantial question of law
I framed matter.
hello then let this matter dispose of this case yeah I taking into account the language you employed in order 22 or order 41 rule 22 this court is of the opinion that an application under section 5 of the limitation act 1960 is not conceived of in explaining the delay for showing sufficient cause in delay in filing a cross objection. The provision of the state provision makes it clear that it can be deemed to it can be permitted by the court. This court, perusing the reasons, is of the opinion that the cross objection can be taken up. There is no delay. It permits the filing of the cross objection. Accordingly, the IA stands closed. The cross objection list the cross objection in the stage of order 41. The cross objection be registered and listed at the stage of order 41 will be
Legal law. Where I for delay condolation and
first time notice that by registered as usual 7 days. It
Yes, order 5.
yes, madam. I know I'm sitting a bit late, but what has happened to your volume? Speak a bit louder. Yes.
As per the previous order, 5 hours.
You filed?
Yes, the date.
When did you file?
They filed 6/5.
Huh?
6/5.
It has been submitted by But it has been mentioned out here in the Korea that you have not filed. Show me what is the filing number? Filing number is what?
5.9.
Huh?
5.9.
Không chịu lại. Miss, yeah, I ni. Huh? Iba ako. Nutun no, 24 no. It has been submitted by the learned counsel appearing on behalf of the appellant that certain applications have been filed on 6/5/2024. The registry shall verify the same and list the matter again on 27/5/2020.
That is what
Huh?
whether there is a structural question or not, because there is a
Oh, that matter.
some other day you see the permit.
What? You don't have a case.
Because matter 3,000 something state per meter for readmission of the appeal. There is some delay. After court, if there is no question, there is question of referring of appeal.
You don't have a case. The question of law which has been framed
Yes.
has nothing.
Whether
That is a question of adverse position, na?
adverse position.
Ah.
There,
There is nothing out there. On that day itself, I would have
my lord, first question is whether the learned court
decreeing the counterclaim of there which is beyond the pecuniary jurisdiction. The jurisdiction was 21,000.
21,000. This is not a substantial question of law.
Gone.
But
Whether
there
the
is a point,
findings
my
of
lord,
the court below are restated by perversity as regards the finding on adverse possession.
that so this
No.
is not- degree was passed.
Huh?
Two degree was passed. One is my method, counterclaim is my lord degree. Against that we prefer only one appeal. In my lord, either we have to choose one method. At first question is gone, my lord. At first question is gone.
Then
the degree
that
in
question
respect-
doesn't.
Degree in respect of the plaintiff is suspended. If it's the method,
That cannot be a substantial question of law. That is too vague.
my lord,
You are opening a Pandora's box in a substantial second.
my lord, there is one point. Regarding my lord, court fee, my lord, there is, I have seen that the court fee, my lord, they have court fee, jurisdictional value is different, my lord, really value is different. But court fee was also not paid.
So,
Only on the kind of thing.
a court fee, if it is not paid, it will raise that issue there. And because of the court fee not being paid, the suit cannot be dismissed. There are lots
Yes,
and
my
lots
lord.
of judgments. So that is also not a substantial question of law.
My lord, court may not have my have
Chalo,
newly
this
engaged,
is the
my lord.
matter again on 16th of May 2024. On which
My
date?
My landed company is there.
Okay, list the matter on 14th of May 2024 at 2 p.m. On that day, it is gone. I'm not going
Yes,
to
my
do
lord,
anything.
actually 2005, I can appeal
It has to finish.
because they have filed the execution in 2021. The second appeal is 2009, my lord. They filed the execution in 2021.
They can do it within 13 years, 12 years.
12 years, my lord. Some month, only 1 month or 2 months.
So that is not.
From that day, we know that the case was our advocate also died. That's the problem.
Okay.
Good.
Don't worry, we may condone the delay, readmit it, and dismiss it. Don't worry,
that will be better,
everything will be done. That day I did what?
That
You
will be
see, condone the delay, restore the suit, appeal, and dismiss.
that will be better, my lord, because justice is seem to be done, my because they, he is also present, my lord.
On behalf of response to the two files,
What?
I have that someone and I have filed a file.
Very well. You see, whatever may be, that appeal is going to go. We don't require the respondents here. Okay, you only appear for condonation. Are all the respondents there or not?
I'm for respondent number 1.
Are all the respondents there or not?
Follow
Well,
here, follow.
That is what I don't require anything. Only that. Like yesterday, there was one appeal. Item number 1. I saw the appellant out there. The appellant had a case. But the appellant is not appearing. No one was appearing. Respondent was appearing. What to do? Then I saw that Mr. Mahmood's name was there. So I saw that anybody representing Mr. Mahmood. So somebody came. I said, okay, you just stand out there for allowing the appeal. Don't require anything. Yes, what is this?
My lord, in this case, my lord, by last order, they said, my lord, your lordship directed me to obtain instruction regarding the complaint before the bar council, my lord, regarding the status.
Why this has come out? This come out for motion?
No, my lord, orders.
Then,
Orders, my lord.
and why are you appearing? Oh, notice is finished. Okay. Yes, then
Well-
you got it. Complaint
My
you
lord,
have filed.
the day before yesterday, it was inquired, my lord. My lord, till now, no effective order has been passed. At my lord, it has not been placed before the meeting of the council. Meeting. That is-
Chalo, let us pick up this matter for admission on the next date. This is the matter for admission on 24th of May. 24th is open or closed? Open, na? Nowadays you have so many colors: green, blue, red.
It's on 27th.
Okay, 27th.
Obliged, my lord.